All right.
Yeah. You mind if I borrow it?
Yes. I'll pull it up on the screen.
Sure.
Yeah. I'm gonna pull
Okay.
it right here. This is probably
Oh,
what you sent her,
yeah.
right?
Perfect. Thank you. Oh, maybe I.
There's the
Yeah.
agenda.
Let me see. Thanks, Chrissy. And these minutes.
Technology is such a pain every time, huh?
One day. Doesn't charge him. I think it was maybe to ask, did we set the meeting in January?
It's always, unless there's special meeting, always just.
Yeah.
Okay, but you don't ever. So you don't go through it?
We had,
Okay.
Does-
I was just asking.
Okay. Are we ready? All right, we will finally get started. Apologies to anyone that has been waiting on us. We're running a little behind tonight. Anyhow, I would like to call this planning and zoning meeting to order at 6:08 p.m. Let's start off with a roll call, please.
Tammy Crossan present.
Shai present.
Oh,
Goodred Espenscheid present.
Crystal Senek present.
Holly Roberts present. And Chase, I believe you're online, correct?
He is, but we have unmuted.
Oh yeah, Chase is present. Thank you. Okay, we're gonna start off with approval of the minutes from November 20th meeting. Has everybody gotten a chance to look over the minutes?
Want to take
Gesture.
They're good.
Is there any corrections or comments on the meeting, the minutes from the
No.
November meeting?
I'll motion to approve them.
Okay, we have a motion. Do we have a second?
Since I
I'll
just read
second.
it.
We have a motion and a second. All in favor of approving the minutes from the November 20th meeting, say aye.
Aye.
Opposed? And what do you, brain just went dead.
He
Aye.
says aye.
Perfect. Chase says aye.
Thanks, Chase.
And I abstain because I was absent from that meeting. All right, so moving on with new business, we are fortunate enough to have some folks from the Wyoming Planners Association here to do a presentation for us. So if you would like to go ahead.
Yeah, I don't know if
Mr.
you're
Bowen?
fortunate. I think Melissa was going to start first.
Oh, perfect. Okay, yeah, sorry. So we have Melissa Ruth is online, and then we also have Andrew Bowen in person. So Melissa is going to start off for us.
Good evening. Can you guys hear me okay?
Yes.
Yes, great. Thank you.
Great. Well, I can't turn on my video for some reason still, but I was able to unmute. So apologies I wasn't able to join in person. The wind really messed a lot of stuff up, it seems like across the state.
It was bad.
Yeah, it's been really fun. But anyway, Melissa Ruth, I am an at-large board member for WyoPass. I am also our legislative liaison. I've been on the WyoPass board for going on 3 years now, and have been a long time resident of Wyoming. And Andrew is there in person. I think I saw him. He's also on our WyoPass board. If you want to go to the next slide, Haley. So the Wyoming Planning Association, or WyoPass, as we're often shortened to, we're an organization or a group of professional and non-professional or layman planners who are involved in planning activities across the state of Wyoming. So we're everyone from planning commissioner members to planning staff to consultants to just kind of average. We do have a couple average, just general people who are heavily involved in development or interested in development. And what we do is we are really an advocacy group formed with the purpose of preserving kind of the quality of life in Wyoming, facilitating coordination and cooperation between planners, and providing continuing education opportunities. So we, in a nutshell, serve similar to like an advice or a association of professional engineers or any sort of group kind of like that. But since planners don't come with an official like seal and stamp and all the things that, give us a lot of liability, we're kind of more of a local grassroots organization. There is still the National American Planning Association, and we're kind of the next step down from that as just a state level organization. And this picture in the background is actually from one of our conferences from a couple years ago. So if you go to the next slide. WyoPass as an organization, so we, again, are a local group, but when you join WyoPass or as a member of WyoPass, There's a lot of different things that you kind of get. So you get a subscription to the Western Planner Journal, which is a journal about planning issues in the West. So it talks about everything from public engagement to comprehensive planning and master planning to specific issues that different municipalities or counties or regional groups are having, and it's kind of like a think tank article compilation of different issues and thoughts and things. We do host a free spring workshop. It's almost always in Riverton, or at least it has been for the past 5 years, where we talk a little bit about the legislative session and everything that kind of happened over the past year, and give some topic-specific presentations on different things that communities in Wyoming might be dealing with. So last spring, we talked about, we did a county and a city roundtable, which kind of was a broad conversation, but we also talked about some of the new daycare regulations and things that changed at the state level. We did a presentation on what changed in the legislative session because it was a big one, and things kind of like that. We also host a fall conference, which is bigger, and it moves around the state depending on kind of the year. So last year we hosted it in Sheridan, and then the year before it was in Cheyenne. We've had one in Laramie, and we've kind of moved it around a little bit, trying to get to other portions of the state, making travel a little bit less tricky, and that's typically in October. We also have online training materials, and we're continuing to kind of build that backlog of all of the materials from presentations that planners have given to the similar presentation to what you're going to see today on planning commissioner training, to basic like statute 101, what does statutes say, and what are the things that affect you as a local government. And then we have an email listserv and kind of feedback, so you can actually connect directly with other planners or other members across the state and ask questions of, what's your permitting process for X, Y, and Z, or how does your community deal with data centers, or different things. And it's really useful for being able to kind of have those conversations and even network at kind of a basic level, since we're all kind of spread out across the state. We also do a newsletter that goes out about every quarter that gives kind of the same updates. So it talks about any upcoming trainings or conferences or things like that, as well as anything that's kind of changed or any news for folks to think about. Sometimes we list like RFPs or work that people are looking for, things that they need help with. And then last but not least is the role that I play a lot of, and that's the legislative updates. So it's advocating for planning at the state level. So I'm over here in Cheyenne, so I go to our state meetings and I talk about what the benefit of planning is, and when we see bills that are proposed that are either supportive or not supportive of local controller planning, I'll speak on them on behalf of our membership, and then I send out updates to the group and take feedback from the group. We do have a website. It is wyopass.org. So if you type that in, it's down on the bottom right corner. It'll take you to our new website and homepage where we've got kind of all of this information, as well as you can click around and see past conference presentations, past kind of information and stuff that we've given out, a list of consulting firms. So if you're looking to hire a firm to do some work, there's a whole list of that, as well as a list of all of our members with contact information. So if you were at a conference or you had a question, or someone said, hey, you should talk to that planner from X community, or that planning commission member from Laramie or whatever, we do have some of that contact information, or at least who those people are from the different communities, so you can get a little bit of information and kind of build that network. I think those are the two slides I have on WyoPass overall. So before I hand it to Andrew to kind of do the planning commissioner training, any questions on WyoPass as an organization, or what we do, or kind of why we're here?
I don't think so. I think that was a great rundown. Thank you. We appreciate it.
Great. Well, if you have any questions, I do have to hop off for another meeting in about 10 minutes. But if you do have any questions, feel free to reach out to either myself or Andrew. Or if you're interested in joining, the link is up on our website, or feel free to shoot either myself or Andrew an email.
Melissa, I will follow up with you, but I was curious what our status was just as a county with membership before we did any renewals. So that was something I wouldn't mind just if we could get that information to see like where are we with it, who all was members before. But I think this would be great for us to be involved with. So.
Great. Yeah, Sublette County, I believe you do have, because Tess, Sol, and Dennis were both members of WyoPass, and I believe a few planning commissioners were, because you guys did attend both the spring conference and the fall conference. But Haley, I'll make a note to see what your membership breakdown was, and let you know it is an annual membership. So if you were good for, say, you signed up in July, you're good through, next July. But I'll take a look at that and get back to you.
Okay, thank you.
Would like to be. We, board members, if you wanted to use the ships and then.
It's
budget.
And it's a group membership that's like up to 10 people. So if we do the group membership, it would include everyone on the, I think it would be great. So, and the commissioners, and then Christy and I would be a separate membership just as like staff versus a board.
All right, thanks,
Correct.
Melissa.
So we do. Great.
Go ahead. No, go ahead. There was a pause.
Virtual meetings are so fun. Nope, that's all I had. So elected and appointed members up to 10 folks can be on that one membership. And then department membership, you can have up to 5, and then there's single memberships. We do also have student memberships. So if you know any students who are interested in planning or being involved, whether UW or otherwise, they can join as well for a pretty low fee.
Great. Thank you so much. Yeah, absolutely. Go ahead.
So Steve Christensen, I'm just curious if WyoPass or perhaps the National Association has model rules and regulations or uniform rules or regulations, and it kind of identifies best practices. Now, maybe there's not something out there. I'm a lawyer by training. A lot of times there's uniform laws and model laws that each state then takes and adopts for their particular needs. So I'm curious if there are any models out there that you've worked with, either nationally or within the state of Wyoming.
Yeah, great question. So as a planner, I'm actually a land use code specialist. That's what I do. And the state of Wyoming does not have, or WyoPass does not have per se a model code. But through our networking and through kind of the conversations we've had, we kind of know who's updated their land use codes recently or their master plans recently, and who had kind of a good experience or not, or the things that they changed. The American Planning Association is the national planning group, and they do have some model codes related to specific topics. So I know there's like a subdivision model code, or as specific kind of concepts come about, there will be model codes drafted. Not all of them are directly applicable to Wyoming, especially given kind of the small staff and more rural nature of Wyoming. But there's also a lot of states that have model codes. So state of Colorado, and it's always a touchy subject to mention Colorado and Wyoming, but they do have a model code that was just developed for both counties and municipalities that touches on a lot of, I would say, some of the issues that we kind of see across Wyoming as well. So there's, long story short, there's a lot of model codes and model language out there for regulations and for master planning and comprehensive planning. but all of it still takes a little bit of tweaking to work for. And I would say that the best resource in Wyoming is the local governments or communities that have updated things recently. So does that answer your question?
Yeah, if I can add, it's challenging, at least for the national APA, to do model codes, just because, and we'll cover it here in a minute, but just the different legislative authorities that counties and municipalities. I mean, I worked in Colorado, I was a consultant in Colorado for 5 years, and what Colorado communities can do versus communities in Wyoming is very different. So, but yeah, to reiterate kind of what Melissa said, I think going after and building these networks, and that's why it's beneficial being a part of WyoPass, is if a county goes through an update, and some counties, Teton County, Jackson, where I work, we have plenty of attorneys looking at our codes because they're always being challenged. So they tend to be fairly legally defensible in Wyoming. Whether the legislature agrees with that or not, we always have kind of that push and pull. But there are a lot of different county examples out there. So. Jump in. It always seems aggressive. All right.
Jump in.
So I'm Andrew Bowen. So I am a senior planner for the town of Jackson. Worked in Colorado for 5 years. And then I was with Teton County for 2 years before that. I'm originally from Western North Carolina. If I don't sound like I'm from here, it's because I'm not. But Asheville, North Carolina, if anybody knows where that is. So a quick question. Don't know kind of board tenure here. How many of you have been on this board for a long time, relatively new? 20? Okay.
I'm just new.
Okay.
This is my six months in.
Okay.
so.
I've been on since 22.
Okay.
6 months.
Okay. Have any of you had training before?
No.
Okay. All right. Well, I'm a pretty open person, so if you have any questions, I don't want to be speaking at you this whole time. It's more to be a conversation. We'll hit on kind of overall, what is a planning commission? What do you do? What are your responsibilities? What is a comp plan? Go into some ethics, general ethics, just because in government, sometimes, especially smaller communities, even larger communities, it's ethical issues, not ethical as in, kind of frame of ethics, but in government ethics, sometimes it's more aesthetic, ethical issues. So we'll talk about those as well. But if you have any questions as they come up, just feel free to interrupt me and ask them away. So what is the planning commission? So you all are appointed by your board of county commissioners. That's the governing body for Sublette County, just to represent the community. And you are members that advises the BOCC. Instead of saying board of county commissioners, I'll just say BOCC if that's okay. On planning, land use, and community development issues. So I know you all are looking at tower regulations to ADUs, subdivisions, the whole smorgasbord of things that planners can cover. You all serve as kind of that staff work on preparing, whether it's text amendments or development review. Staff pushes that up through you all, and you all are kind of that first vetting process and that advisory role for the county commissioners. Planning commissions are also really important because they're often kind of the first step in that public review process. So at least in other trainings, some planning commissioners, and I've been on I said complaining commission.
Yeah.
A
Pretty
planning
much.
commission, a planning commission before, and a lot of times that wasn't really known, that you're kind of that first big step in that process, and it's very important. This is where the vetting starts, is with you all. So who does the planning commission represent? You all do not represent yourselves, your neighborhoods, the town or unincorporated area that you live in. You are here to represent the county at large. And that's very important. So you have to bring in a broader context of, is this good? Is this good for my area? Is it bad for my area? You are to be open and fully look at how is this going to affect the county at large? Not just myself and my neighbors or this small area, but how is this going to affect the county? Planning Commission should strive to provide input and guidance that will positively affect the entire jurisdiction. Again, just think about, try to put on a county hat when you come to these. And I don't want to sound preachy. Trainings often sound preachy. So if I get too big, just let me know. But truly just having an open thought process of how this is going to affect the full county, whether it's urbanized areas or the rural parts of the county. So responsibilities of the commission. So be familiar with the proposals, applicable regulations, and if you have questions, please ask staff. As a governmental planner myself, it is very helpful when a commission comes and they have read through the documents. If you have a question, you ask beforehand. If there's something that, if you have a question or concern with a proposal or a text amendment, just as a courtesy to fellow planners, it is it's great to kind of bring those up prior to a public hearing. You know, all planners have been presenting when there was an issue with a permit, and planning staff might put that in staff report, may have missed it. You know, we all make mistakes. But it's really helpful if one of you all in your review of a packet and you see something, you know, say something and ask those questions and try to get that taken care of prior to that public hearing. Sometimes, you know, if it's a general question, sure, that's the appropriate time to ask at a public hearing. But if there are any kind of deeper questions, of course, you all can't meet with your planner together, but individually, you know, pick up the phone. I don't know your communication style yet, but that's at least what I appreciate, is kind of taking care of those issues before a public hearing. So another key issue is just to be consistent with your decision making, and truly only focus on the proposal that's being considered at that time. Take public comment through public hearings. Be sure to disclose any communication. We'll go through this a bit in the ethics training, but you all, as you review development proposals or you know, any other permits, kind of in a quasi-judicial manner, and we'll go over that in a bit. It's very important that if you're reviewing a proposal, and you're going to review that in a public hearing, if it requires a public hearing outside of text amendments or rezonings, if it's an application that comes to you and it requires a public hearing, it is going to be a quasi-judicial meeting. And that means that you all are acting somewhat as a court. So all testimony that is being taken, and that's what it is, an applicant comes or staff comes and they provide you with the information at that meeting to make the decision at that meeting. So it's very important that if there's a subdivision or something going on that is going to come to a public hearing, that you all are not discussing these issues with the applicant outside of a meeting or disclosing information or even talking about it with your neighbors. This is kind of a shell that you all operate when you're making these decisions.
Yeah, I just want to make sure that, because the microphone's not close.
Oh,
I wanna make
sorry.
sure that, like, Chase, are you? No, I should talk.
Chase, can you hear? Just want to get a check. There.
Oh, it'd be good if you talked.
Okay, yeah, sorry.
Can you guys
and
hear
then-
me?
Yeah,
Oh, great. Yeah, I can hear fine. Thank you.
awesome.
And then lastly, on kind of responsibilities, consider the future of the community and developing plans to guide growth and development is both complex and consuming. So, you know, this is tough work that you all are doing. And I get it both on staff side and being in your seats, that there's a lot of pressure sometimes from the decisions that you all make. And well, not the decisions, but the advice that you give to the POCC. So congratulations, and, you know, as somebody that works in this space, thank you for what you do. Because I know it pays very well. It
Very,
pays,
very
in
well.
Non-alcoholic punch. So what can you do to be a better commissioner? And I'm sure you all are great, but kind of key takeaways is ensure you're familiar with code and the proposal and applicable regulations. Sometimes it is frustrating when, and again, I've served several different communities and there's different levels of engagement from board members. But being familiar and coming with the understandings that you need to be able to make that decision is very important. And again, if you have a question or if there's some technical issue that you're trying to work through, it's jargony planning, you know, planner speak, or it's something technical, you know, just ask, and hopefully kind of take care of those issues before the meeting. Be consistent. Again, listen to staff. They are here to be your professional and your guide through this process. And then listen to the public and conduct public hearings. That's your main responsibility, is making sure that these go through public hearings. So Wyoming state statutes. So this is the legislative authority. So Wyoming is a Dillon's rule state. So other states, such as Colorado, most communities are what you call home rule states. So they have broad discretion over how they can regulate their communities. That is not the case in Wyoming. So these titles and statutes are your legislative authority. And these are very important that you kind of follow the parameters that are in these statutes, because and I'll send these slides. I'll send these slides. You don't have to take
Okay.
So, but just be familiar with these statutes and what they say, and how they kind of inform the questions you can ask, kind of the avenues you can go down in your review process, because where you come outside of those bounds, that's where the lawsuits and litigation can occur. So the big ones for county and planning legislative authority is 18.5.201 and 18.5.208. I'm sure those are now stuck in your head. For administrative procedures, so this is how to conduct meetings, your due process laws. That will be statute 16.3.101, 16.3.115. And then Title 34 is property conveyance and security transactions. This is your public access and right-of-way dedications and plats and town sites. And then already made this note, I've always called Dillon's rule states as kind of Mother May I states. So you have to, you know, you don't have permission until it's written in the statutes. And that's not derogatory. That's just the situation of being Dillon's rule communities and Dillon's rule states. So again, it's very important to follow state statutes to avoid litigation.
Can I ask a question?
Of course.
So Wyoming is a Dillon's rule state.
Mhm.
What are some examples of some other state, like rules that some other states implement that are different than the Dillon's rule state?
Yeah, so like in Colorado, you'll find in Wyoming, if you do research on codes, you will see that most codes will follow kind of the same. They're generally the same, and it's because those codes are perimetered by legislative authority. If you do the same thing in states such as Colorado or New Mexico, where they're not Dillon's rule states, those communities have very tailored regulations for their communities. So, you know, good examples would be in Colorado, there's far more counties and municipalities have far more leeway in mitigation fees, housing fees, stormwater fees, you know, all of these different things that some we currently have in the state of Wyoming. But that's where the big difference is there's a lot more, communities can have truly specialized codes of ordinances in those types of states. It's not good or bad whether you're a Dillon's rule or a home rule state, it's just the framework we work in.
Does one provide more flexibility in terms of code implementation than the other?
Yes, home rule communities definitely have more authority. Where it really comes down, I guess, is the ability to kind of legislate your own community. And that's the big difference is home rule communities or home rule states grant their jurisdictions far more authority and discretion in what they can do in their own. Again, not saying it's bad that we do not have that in Wyoming, but that's just, and North Carolina, a lot of your southern states are Dillon's rule, Midwestern states are Dillon's rule. A lot of your western states are home rule states, especially kind of around the Sun Belt. Any more questions? All right. So planning, let's see. Oh, these are more. Statute 18.5202, Planning and Zoning Commission, composition, residency requirements, terms and removal of members, vacancy rules, records, meetings to be public, secretary preparation and amendments, purpose, certifications, and hearing and amendments. So, kind of outside of all of that information, county planning and zoning commissions have to be appointed by the Board of County Commissioners, and they must be comprised of 5 members, and 3 of whom must reside in unincorporated areas of the counties. So that's statewide. That's the composition rules of our county commissions. The Planning and Zoning Commission may prepare and amend a comprehensive plan, include zoning to promote the public health, safety, morals, and general welfare of the unincorporated areas of the county, and shall certify the plan to the Board of County Commissioners. By the plan, I mean the comprehensive plan. And the commission shall also prepare recommendations to carry out planning and zoning proposals and certify those recommendations to the Board of County Commissioners, and certify there is advised. So what is a comprehensive plan? So a comprehensive plan or a comp plan is just this county's long-range planning document. It is advisory in the state of Wyoming. It's not regulatory. So it is more of a vision document. Where are we going? Where have we been? And what decisions do we need to make pragmatically to get to the direction where we want our community to go? It is generally staff kind of works on a comprehensive plan, whether that's in-house or with a consultant. But then again, you all are the first vetting process. Again, as you all will see tonight for these types of decisions, you are kind of the first vetting process for the comprehensive plan and to go through that. I've worked in several communities where the Planning and Zoning Commission take a very active role in kind of community engagement and kind of running those engagement, just because you all normally represent different parts of the community and are a great way to kind of have neighborhood engagement, especially for smaller communities that don't have kind of a robust consultant working on these plans. And then again, already covered this, but the comp plan is advisory, not regulatory, but it provides a foundation for the decisions that you all are making, both with your development proposals and your LDR or code text amendments and other decisions that you make. Go ahead.
I understand the makeup, but the comp plan is the vision document and the regulations are like effectuating the comprehensive plan. It is the regulatory basis, but the comp plan does, to some extent, is regulatory in the sense that we do tie it into in cases of hearing certain applications, it has to conform
Your findings
with one of them, often either factors, findings, it depends on what the application is, but does say it must conform with the comp plan. So to that extent, it does tie back into some regulatory control, right?
Yep.
Cool.
So Is there any kind of standard or on average of how often a comp plan is revisited? Or is that just kind of,
The model used to be 20 years, you know, because it's a comprehensive plan, it's long range. I would say best practices now, most communities are at least going through heavy updates of the comprehensive plan every 8 to 10 years, especially in communities that are in change, just because what you had 10 years ago or even, you know, 6 years ago, might not be what you're looking at now. And in implementing comprehensive plans, sometimes there's kind of, there weren't mistakes, but you realize kind of the factors that you put into that comprehensive plan. And you might need to pivot in different directions and adjust a few things. So yeah, I would say every 8 to 10 years at least, you should be looking at maybe not a full comprehensive update, but at least really taking a hard look at your comprehensive plan. If you have, you know, an implementation matrix or different policy directives, kind of take, you know, an account of what you have accomplished, what you still need to do, and then kind of move from there. And then also, you know, when you have when you have kind of heavy periods of text amendments, those need to be guided by the comprehensive plan. And they need to reflect what your community has said through the comprehensive plan. So if your community is feeling a lot of pressure to go through, you know, heavy text amendments, that's a key trigger in knowing that, well, maybe we need to look at our comprehensive plan bit.
Can I ask a related question? Did you have another one?
no, go ahead.
Kind of related. I mean, so my understanding is a lot of, you know, at some point early in the planning and zoning process, when a county's established and they start, there's a zoning map that's created. Are zoning maps revisited periodically? And if so, how frequently does that tend to occur?
Yeah, so zoning maps, you know, they are pretty, at least in most communities that I've worked in, they're pretty concrete. You know, your zoning map amendments are normally driven through by development. At least that's the general scenario. But yeah, I mean, if you know, take the town of Jackson for example. You know, we went through our last big zoning update. I mean, it's been a long time. You know, and most of your fluctuations are going to be if you do have, especially in the county, if you have urbanizing areas in the county that are close to urban areas, those are the areas that might flux more than others and might need to be looked at more.
Yeah.
But you know, I would say that kind of your outlying parts of the county will remain the same zoning for quite a long time.
I mean, what we see is, I mean, so like, obviously they established it when it was a different size population and different sorts of industries and stuff. So I think, you know, as population grows in Sublette County, we see, you know, there's starting to be rezoning and stuff in places where maybe if you were going to do it in an orderly way, you wouldn't say, oh, we want sporadic commercial things living in the middle of A1 areas. You might say, well, let's put density around density or whatever. There'd be some thought process. And so I guess, you know, if the county wanted to revisit, how do we, you know, all right, we're a different county today than we were 40 years ago, 50 years ago. How do we want to plan for growth now, not just through the comprehensive plan, but actual zoning map sort of stuff?
Yeah, so that would be in your comprehensive plan. That would be your future land use plan or your future land use map. And that's your zoning map right now. And it's using kind of the comp plan process and what the community is seeing as kind of potential areas that might need to be rezoned, whether it's upzoned or downzoned. But that would be your future land use plan that would kind of govern those decisions. Those are mandatory in some states, not in the state of Wyoming. But I would say are, you know, a vital tool for a community, not just looking at its current zoning map, but having a community vetted future land use plan. And that is tied in with a map And then you also have kind of your character districts that kind of tell the stories of all of those potential future
That's interesting. I
zoning
don't think we
districts.
have that as part of the last comp plan that was done. That doesn't sound familiar. That's interesting. That would typically be part of a comp plan?
Yeah, that again, that's not going to be as common in Wyoming, but in
Okay.
most states, even around the West, you're going to see future land use plans, and that's kind of your zoning map 1.0, kind of in the future.
Sorry to sidetrack. That's
No,
very
no.
helpful. Thank you.
That's great. Any other questions on this slide? All right. So why the comprehensive plan matters. So I think I've already gone through most of these, but again, it's your community's vision. It's kind of your guide towards making decisions. Does this jive with the comprehensive plan? If it doesn't jive with the comprehensive plan, why and how can we justify it not jiving with the comprehensive plan? So that's kind of the decision you all need to make. And it's fine if it doesn't align with the comprehensive plan, but you all as a board need to be able to say why it's okay that it doesn't align with the comprehensive plan. It provides policy guidance for zoning, subdivision, and development decisions. It helps ensure decisions are consistent, defensible, and transparent. It also helps the development community have some probability that they know how a development review process is going to go. And it serves as a reference point for evaluating development proposals and amendments. And again, I've already stated this once, a comp plan doesn't approve or deny projects on its own, but it does help explain why certain decisions are made. Subdivision. So the Wyoming statutes do provide kind of broad guidance for counties of how they regulate subdivisions. Because of the enumerated powers of the statutes, counties have the right to develop subdivision regulations, but they cannot conflict outside of, again, the bounds of what the statutes allow. But your subdivision regulations around around Wyoming they do tend to be different from county to county, just because that is a place where communities do have some discretion. So, Planning Commission relationships. So, the Planning Commission's primary role, again, is to advise the BOCC. Commissioners should recognize the limit of this role, and final decisions rest with the BOCC. And maintaining a strong working relationship requires keeping the BOCC informed about planning issues and providing clear and well-reasoned recommendations. And also, serving as champions of the planning department, supporting staff, helping staff. That's a big role that planning commissioners can have as well. And then on the planning staff side, planning staff play a vital role in the land use process and the effectiveness of the planning commission. For this to work well, staff and the commission need to function as a cohesive team. And the commission provides insight into community needs and values, while staff offers the technical expertise and the analysis for you all to make your recommendations to the BOCC. And then staff is also responsible for administrating land use regulations, conducting research, and preparing plans, reports, and recommendations. This next one is a bit duplicative, but commissioners should openly share their perceptions of communities, attitudes, and concerns and priorities with staff. So that's a vital role. You all are here to represent the community at large. And, if there are issues such as, hey, I keep hearing, there's an issue with this section of code, maybe we should do something about that. Having those open lines of communication is really important. All right, so public hearings and meetings. So it's very important. I guess you all use Robert's rules. Okay. So very important to understand kind of how to run meetings. In general, do you all, when you have kind of a proposal in front of you, do you kind of have a checklist or a guide sheet that you use?
But you mean an application?
No, like a guide sheet of,
You said when you have a proposals. I mean,
Yeah, like when you have a proposal that you're deliberating over, kind of a guide sheet on how, for the chair on how to run a meeting.
Oh, yes.
Okay, because, whether you've done it 1,000 times or not, sometimes in these meetings, you can get called and there can be litigation for very small procedural errors. So having kind of those cheat sheets just to make sure you're running your public meetings correctly, that would be my advice at least.
it's kind of baked into our bylaws.
Yeah.
Running of the meeting.
Yeah. And then explaining procedures, go over them with yourselves, but when you open up the public hearing, kind of explaining how this meeting is going to run to the applicant and the public, clear direction to the audience, time limits on comments. I don't know if you all do that or not. Stick to the agenda, control the meeting. And by control the meeting, I've worked in several communities where community members want to turn around and talk to the audience, or you'll get one public comment and then you'll get another and then you'll get a rebuttal. It is up to the chair to make sure that does not occur. Everyone here that stands there is here to discuss this proposal and give their testimony to you, not to the room. So just keep that in mind. And I don't have to tell you this, but be respectful to everyone. Speak through the chair. If public comment is closed, keep it closed. Have that all the time, and not necessarily in Jackson, but in meetings that I've been in where public comment has been closed, the record for public comment has been closed. You all start deliberating, and then someone wants to step up and speak. It is best to not let them speak. It seems harsh for the chair to have to do, but what it really does is then you're favoring that comment over everyone else. So you should technically reopen the public hearing if you're going to allow that to occur, but you shouldn't, because then that just muddies up the records for the clerk. And you really need, the clerk has to be able to have very clear segments that's followed and tracked through the public record.
Just to follow the line, to just make sure that we have clarity here. I mean, that talks about public comment, but I would assume the same is true for the applicant too. If the applicant's time is over and you said, okay,
That's correct.
we're moving into deliberation mode.
Yep.
Then the same would be true for the applicant.
Yep. Yeah, and even, technically, if there's a motion on the floor and you all are deliberating, really, you're not even at that point supposed to ask staff any clarifying questions. Those questions really need to be asked before a motion is made. It's fine. It's not going to be an issue if you have a question for staff. But again, just for clear records and clear minutes, following that process.
Yeah, I mean, what has happened pretty frequently in deliberation is we might have a question for the attorney, because, right, we're, oh, well, what about this, that, blah, blah, blah. So it is hard not to do that sometimes.
Sure. No, I get it. And then use your staff for clarity. If you have questions, ask them. Findings, their statement of evidence and reasoning used by the commission to arrive at a decision must be supported by facts. Typically include request description, statement of facts, reason for approval or denial, and condition of approval. Do you all do findings of facts? Okay.
Under certain things. Let me ask you about that, because it's fairly common that we have applications in front of us that do not have enough facts in order to us, like it's insufficient facts, or we say, how did you come to this statement? Oh, well, it's just my personal opinion. And so I feel like we've been in the predicament many times where we have an application in front of us, we don't have facts to make our decision, to which I assume the default would be, well, we don't, that you would vote against it if you don't have the facts in order to make the findings, because otherwise would be, you wouldn't be doing your duties, is how I would read that. But I'm curious what your take on that is.
I would say if you do not feel comfortable at that time making the decision, you don't have to say no. You can continue the meeting and you can say, hey, we cannot make this finding. If there's some professional report, there's a geotech report that we need. If there's something else that we need, we can't make this finding. So we're going to continue this to a date certain or a date uncertain until we get that testimony that will be able for us to make that finding or not make that. Cool. And then the record is a collection of all the evidence presented to the commission during proceedings, is the foundation upon which the commission's decision rests. Findings in the record protect the commission from legal challenges and explain commission's decisions. And the record includes proper minutes of the meeting and always a decision letter from the planning staff or commission.
Does the record include verbal statements made in the hearing that do not end up as a written thing?
It depends on how your clerk takes minutes. Most of the time, some discussion should be covered, but again, I haven't seen your minutes, so I don't know how, if they're just kind of the decision points that were made or if it's a record of discussion. I will say that what is said in discussion doesn't matter. It's what comes out in the findings, or if there's conditions of approval or something. If you have a robust discussion at the dais with an applicant and they say they're going to do this and do this, but it's not part of the actual request, if you do not put that in your motion as a condition, they are not held to what they said.
Yeah, okay.
So it's very important that if you are like, well, we actually need 25 feet of right of way here, whatever that is, and they're like, oh, sure, we'll do it. That has to be a condition that's placed on that application.
That's important. I don't think we've always done the best job at that. That you want to just be like, oh, okay, they said they're going to do it. Let's move forward or whatever.
Motions are very important.
Yep.
So next, a bit about ethics. I'm sure you all are ethical people, as we all are. But kind of governmental ethics, sometimes there's questions. So again, you're here to serve the public interest. Commissioners represent the entire jurisdiction. Again, I've said this, I think, 3 times, not individual interests. Decisions should advance public health, safety, and general welfare of the community and avoid favoritism or special treatment. And again, must be consistent. It's okay if 5 years ago, the county made decisions like this, but there has been some community change that has kind of changed that. There's no real precedent that you all set in your decisions, but we do need to try to be consistent. But if there is a reason for a turn of direction, if the county is no longer, due to growth pressures or something else is no longer more favorable towards certain decisions, that's completely fine, but just openly deliberate that and discuss that in your meetings. Impartiality and due process. So keep an open mind until all testimony and evidence are heard. When I was going through school, I had, I think it's impossible for you all to get a staff report and not have a decision in the back of your mind before you come. It's very difficult. But you all are here. Your decisions and your mind and the decisions that you all make in your yays or nays should be strictly influenced by what someone says at a public hearing. Again, that's very, very difficult. Some states in quasi-judicial processes, planning and zoning commissions don't even get a staff report prior to the meeting. They come in completely blind. Those meetings are very long.
There's no documentation?
No document, no.
Wow.
They get the kind of the subject. They know seemingly what it's about.
Jeez.
But they come in and those are very, very long meetings. So that's why most places do not do that. And I will say those places also, the reliance on staff to be, they have to have a great trust and working relationship with their staff, because they can't be like, oh, I'm gonna look at the floor area ratio real quick and make sure this is right. They're coming to those meetings with the understanding that they're really just looking at the discretionary points of that application.
Yeah.
And then keep an open mind, I already said that. Base decisions on the comp plan, adopted regulations, and and evidence in the record. And personal opinions or community pressure should not replace adopted standards.
So can I ask a question just to
Yeah.
clarity, which I think it's answered, but I just want to say it out loud because I think in my time on the board, I have seen board members of past say like, we all have the regulations in front of us. It says one thing, and we've had some folks on the board who are let's say anti-regulation. They don't think we should have regulations. And so we all have the same thing. It might say something, but their opinion, whether you're anti-regulation or not, let's say I have a strong opinion that I don't like that regulation. I wish it changed. I wish it wasn't there. So I'm not going to vote. I'm going to vote. My opinion is going to be based on, or my vote's going to be based on my opinion, not on the regulations. I would take that to be a misalignment with what our duty is based on what you're saying.
Yeah, not only is it a misalignment, it's possible litigation.
Mhm.
You cannot, the decisions that are made in these quasi judicial hearings, they have to be based on factors and
So it
testimony.
doesn't matter if I don't like it. I got to
Yeah.
remove my opinion from it and follow
Yeah,
it.
it's just like if a judge is like, I don't agree with this law, the speed limit should actually be 98 in the school zone. I don't care about that. Obviously there would be some pushback there. So again, opinions just for your own, you should just leave those. What the code says is what the code says. If there are board members that have disagreement on what the code means, again, I think that is
Right, that's a
that
different
is
thing.
that is up to you all to lean on your staff. And I would say that your staff's interpretation of that code, that's the professional interpretation of that code. And I think this board should lean on that, unless there's reasons not to, but. All right, and then a bit more about ethics. So to recuse or not to recuse, this is something that comes up very often. And conflicts of interest. So a planning commissioner should recuse themselves from a matter when their participation could create a real, so that's a financial interest if you're going to financially benefit, if you're going to get true benefit out of a proposal, you should obviously recuse yourself. There's also a perceived conflict of interest or compromise their ability to act impartially on behalf of public at large. So, if you serve a nonprofit that builds affordable housing units or helps funds affordable housing units, and it may not be your nonprofit or whatever that's developing these, units, but if something like that comes, aesthetically, you probably should recuse yourself just because there might be the perceived that you cannot impartially make a decision based on this because it's something that you do. Does that make sense?
It does, although that's pretty broad. Like, I mean, like not to point on anybody out, but like we have a real estate broker.
Yeah.
Like under that example, that sounds like how could they be part of any application? Like like I wouldn't, the example you just gave, I wouldn't probably think, oh, they should recuse themselves because they're a party of a nonprofit that's not associated.
Yeah. Again, when there's not a legal conflict of interest, it is up to every one of you to make that decision. And if you can live by that decision and you can truly be impartial to whatever's occurring, then that's completely fine. It's up to each of your personal discretion for these more kind of perceived conflict of interest. I would say for more, unless you are very much needed for a vote, if it's a very controversial project or application, and your decisions and your review is going to make the general public feel as though your all's job is being sullied somehow by conflict. Again, that's just a decision that you all have to make.
Yeah.
So I already went over this a bit, but ex parte communication, again, you all operate in this building. The decisions that you make are behind this table and should be based on what is said at the dais. If you are at the grocery store and someone comes up to you and they're like, hey, I've got this development coming up, I have an application in with the planning department, that's ex parte communication, and legally, and the reason why this is important is because everybody should be privy to the same exact information, whether it's the opposition, whether it's the applicant, or people coming maybe in favor of a project, and you all and planning staff. All of that information should be exchanged in live time with everybody that's involved. Any information that is dispersed outside of that, and a lot of boards, sometimes a planner will send out something and somebody will reply all. And then that's an issue. It can sometimes it can go into the illegal meetings world, but also can be ex parte communication amongst you all. So it's best just to remember that when I'm notified that this application is coming up, I'm to not talk about it to anyone or listen to anyone, not post about it on social media or read social media stuff about it. This is where, I am to make decisions on this.
There's been a couple of applicants during an application process that have taken the Board of County Commissioners out to dinners. That seems to me like that would be ex parte communication.
If they're not discussing the proposal, that would not be
But if
considered.
they were, it wouldn't fall in the line of what might be considered ethical.
Yeah, and it just depends on the process. If it's, again, you have legislative meetings where you can talk to whoever you want, and then you have quasi judicial meetings with findings and testimony, and you cannot talk to whoever you want. So it just depends on what context you're operating in.
So in regards to public comment, because I feel like it's pretty on the regular that I'll have not the applicants themselves, but I'll have the public contact me personally, and I always make sure that I pass on the comments, but would that be included in that, or like if it is someone in opposition or in approval of something that's coming up, but like for whatever reason they can't make it to the meeting or whatever. I mean, it's pretty regular that I have people like verbally contact me.
Yeah, so, if you're not communicating back, that's not, it takes two to communicate. If you are getting comment or someone sends you something, forward it to staff. But then also when the meeting starts, when the hearing starts, next point, segue in, you need to disclose that. Hey, I
You
received.
do. That's what you do.
Yeah.
Okay.
So I received these comments, and then just follow up. In no way did these comments, are they going to weigh on the decision that I've made, or that I'm going to make? Just make kind of that point clear, that you've received the comments and acknowledge that you got them, but you're here to make decisions based on the testimony that's provided at that meeting.
Gotcha.
So I have a question. What about if you haven't received any comments, but you're curious about what a community feels about a given, can we go out and ask around, or should we not do this?
You should not, again, you shouldn't be trying to gather kind of community testimony outside of the public hearing. It's, it's just because, again, the information that you're collecting isn't going to be part of the official record at that meeting. And that's really what it's about, is that all information, all study, all conversations need to live in the record for that hearing. You can go visit the site, you can look at it, you can look at the plans, but no, having conversations with neighbors, how is this going to affect you? That is not appropriate within the quasi judicial context.
So just suggest to, if people do come to you with comments, you can encourage them to send an email, and then it can be, are they written documentation of their comment, and rather than just the hearsay during the meeting. But I understand sometimes, not always easy to get people to sit down and actually send an email.
They like picking up the phone and calling.
Yeah.
That's a question too. If someone calls me with, do I really theoretically need to have it in writing, or can a verbal comment? Can I include a verbal comment with the staff? Or I haven't had that situation.
Yeah, you can provide in a staff report, I had a phone call and this serves as their public comment. I would encourage, just so you don't have to do that, hey, it was great discussing this proposal with you. Could you just send me a follow-up email? And so I can stick it in the record.
It is funny though.
Hey, I'm not sure if
Um,
that was Haley talking last, but could not hear you online. Whoever that was.
I'm sorry, I didn't have my mic on. Oh, sorry,
I
Chase.
can hear you now. It's okay.
Sorry, Commissioner Chase.
Yes, so she was just asking questions about when she gets comments via telephone or conversation, if those need to be placed in the record. So,
I mean, the other thing that I think about, which I've never thought of as being a bad thing, but maybe it is like, the applicant might call the members of the P and Z or the BOCC and say, hey, I want you to come out and check out, what we want to do. I want to show you the property and show you what we want to do and what our plans are, which always seem like kind of fact-finding sorts of stuff. But it sounds like that may not be
I would tread those waters with caution. Because again, if they're not there and they say, hey, this is where the site's going to be, here's the site plan, because that's included in the staff report, sure, that's fine. But if they are there, if I'm in opposition and I hear that you've been with the applicant talking about the proposal, the benefits, how it's going to be great for the community, I am going to call into question if you actually came into this meeting with a partial, being able to make a partial decision.
that's happened on several occasions that I can think of. More the BOCC than us. I mean, but it happens a lot, I think.
If that is something that occurs, I would encourage the applicant to arrange something with staff to take one or two you at a time to visit the property, because it's not ex parte communication. This is important. You can ask questions of staff at any time during this process. That is not, think of it as your attorney-client privilege. You can discuss a proposal, whatever you want, at any time prior to the public hearing. As soon as you have, that the staff packet in your hand, and if you want to go visit the site, I would encourage staff to be involved. Again, just to make sure that there's no perception of ex parte communication or bending of ears, if you will.
The BOCC needs this training too.
Yes, yeah. Andrew, I have a question for you. Oh, I'm so sorry. Do my weightlifting today?
They are pretty good.
They are. They only work because they are heavy. So just with what you brought up, a lot of times people will stop me and ask questions or call me up or whatever the case is. So I'm just going to have a t-shirt made for all of us that says, sorry, can't talk to you.
I'm in a bubble.
Absolutely. I love that idea. But I think a concern comes to me because our county engineer is also one of our engineers is like Rio Verde, who goes out with the applicant and is charged with performing the application and then bringing it forward to the commission. And then we, of course, send it on to the BOCC, but they are the county engineer. So do you see a huge conflict with that? Because from what you just discussed, I do.
I am not going to speak on the inner workings of the county. That happens.
But from what you just said, it could be a huge issue.
Again, I understand where you want to go. But
No,
those are discussions, for the county to have. And small communities, these are challenging metrics to always hit, they just are.
Well, I am concerned about, because we're supposed to be out there representing the public.
Yeah.
And it's really hard because I have gone out to the public and said, hey, what do you think about this? Because I am curious. And, maybe it's wrong, but I think that's what we're tasked with to a certain extent, especially now, maybe not with a certain application,
Yeah.
but with the regulations that we're trying to rewrite. I do it all the time, but this is different
Yeah, again.
than
if
an
it's-
application.
If it's a rezoning, if it's a text amendment, you can canvass all you want, all day, every day. But if it is a development proposal going to public hearing, you should not. And, you can, it's just setting, it's just, and I think it's a matter also of kind of community education. You know, that there's a reason why we can't do this. This could lead the town into litigation. There's issues with due process, constitutional rights, why we cannot, I can't meet you at the coffee shop and talk to you about this application.
Absolutely. Follow up. I think. No.
No.
Okay, I just want to follow up too. I have just to follow up about the county engineer thing, because this has come up and I am still looking into this a little bit, but from my understanding, they are more the county engineer when it comes to road and bridge, and not necessarily the full county with like overseeing planning and zoning and other developments. That's more, I'm still trying to get an understanding of all of this, but that was something that was communicated to me because I feel like I've had questions about it as well with reviews and trying to make sure that we are doing thorough reviews. And we just ran into this with a plat review. So I am still trying to receive a little bit of clarity about that as well. But that's my understanding now.
So not through the Sublette County context, but I have worked in several communities where this has been an issue. Whether it's an architect or an engineer that serves the community and does referrals for applications. We had an internal policy that was not allowed, that it had to go to a third-party review, and we had that third-party reviewer either on retainer or with some sort of agreement that they would pick up those applications. as they did. But whether it's right or wrong, I don't know. To make that clear. All right. I think that's it. Questions and discussions.
I wonder if, because there's been, I'll say that some of us, and I'll call myself out, like to use conditions on applications where there's ambiguity in order to like create clarity so that we can move it forward, sort of thing. But I think others are less into putting conditions on things. So I wonder if you could just talk a little bit about like where, when, conditions make sense. Are they a good thing, a bad thing? And here, let's think about, I think it's typically in the conditional use permit sort of thing. So I'd love to just hear your perspective on that.
Yeah, I think it, if you have to condition, I think that's fine. I think the ultimate goal is, hey, we can't approve this at this time. We need these things reflected in the application packet. Conditions often serve as, sometimes they're headaches for staff, and speaking as a public planner, I write conditions all the time. I try to get those things worked out prior to a public hearing. But kind of conditions are your last resort. Okay, we cannot approve this unless this is done. But again, I would encourage applicants to try to work through those prior to.
So create clarity first, even if it means continuing the
Yeah.
application, get as much clarity as you can, and only if you have to use conditions.
Yeah.
Use conditions. That's interesting. Yeah.
Unless the applicant is fine with that, and applicants in general, I've been a consultant too. Applicants seemingly don't always like conditions. Also, sometimes it's necessary because you've got time constraints for your development process that you have to meet. You need this to be approved by this time, and that's the process you need to take.
Yeah, typically applicants want a decision on the night they come. They don't.
No, I
want the
get
idea
it.
of delaying. But, isn't it, I always thought of, well, conditional use permits are things that by their nature, if they were by right, could be harmful, and therefore they're conditional uses because they need conditions in order to make them fit within the specific circumstances. So But I do like the idea. I think we have used conditions as a way to quickly move instead of delaying applications. So I do like that's an interesting concept. Just delay the application until you can get greater clarity.
Yeah, if the applicant's fine with that, again, it's their right to come to you all with an application, but it is not their right to have an application approved or denied on a certain date. Your legislative authority, your code gives you a shot clock of when you have to hear something. It doesn't normally, and I need to look at your code, but it normally isn't going to tell you if you have to approve or deny something by that. It's just, you have to open that public hearing by that time. Now, you can't keep continuing something, to get your honeydew list done. But in general, I think if the applicant's fine and they're willing to work with staff to kind of clean up some of these issues, again, just keeping a clear record, clear plats, clear subdivision plans, it's just better sometimes to try to work those things out. That might be a personal opinion.
No, it's
I-
useful. Thank you.
I think that's an observation. I haven't been here for a very long time, but it does seem like I've observed in meetings that typically it feels like a decision has to be made during that meeting
Mhm.
rather than sometimes being like, we can maybe slow this down rather than making a recommendation that isn't. Maybe there needs to be a little clarity instead of just trying to receive the clarity before the BOCC meeting.
Well, yeah, and I think maybe there's kind of historical reasons why that's the case. I think before we had our bylaws, the only basis on which we had to like table an application was if we could ask for input from a federal agency, or
Mhm.
not federal agency, an agency, or look for an expert. But we couldn't continue it and just say, we need clarity on these issues. But our bylaws said now that we can, so we can. But
Mm.
I think that was kind of built into the culture of the board, like we need to do this tonight.
Yeah, and not speaking to this county, but in general, you all are there to serve the community. You have no service. While the applicant may be a part of your community, you are here to serve, but you are to serve the broader community. So you should not feel pressured by an applicant to make a decision that night if you do not have what you need to be able to make the findings to make that decision.
That's helpful. Thanks.
So I have a question for you. That's not really in regards to your presentation or your training, but it kind of goes back to the current situation that we're in and trying to revamp and rewrite our regulations. And we've kind of gone through several different procedures in the process. In general, in your opinion, is there a better way, like one way that's better than the other to attacking like such a huge task? Because currently we're doing the tower regulations just because we didn't have any kind of regulations for that. But beyond that, we've currently just tried to take the whole thing and we've broke it down and discussed it but I still feel like it's still is a huge task.
Sure.
We did hire a consultant, which did not work out. But we're kind of not back to square one.
Yep.
Because especially the previous commissioners put in a ton of time into it. But I'm just wondering if there is any input, some way to make it more efficient.
Yep.
I don't want to say streamline it because I don't want to take the easy way,
Sure.
but to make it a better process.
Yeah, so your code needs, again, to be guided by your comp plan. So if you are looking at large, if you're amending a large proportion of your sections, if you're making big changes to what has been done for a long time, you might not need to do a full code update, but you do need to at least take a community pulse. And, it is very important for the community, staff, and you all and the BOCC to really take a look at what's working, what's not, what's broken, what had outcomes that we did not foresee? What would we like to see more of? Going in to do text amendments unguided without that is going to be a long, arduous process. Just because you need that information. Now, if it's tower regulations, that does, that's a pretty surgical amendment. But if you're maybe not, as I just like the word surgical.
Thinking.
It's a very surgical amendment, okay?
It's a delicate surgery. A very long surgery.
That's just, it might be a chronic issue. But no, if you're making targeted amendments, taking care of, things that you might be reacting to, that's fine. But even, again, if you're reacting to a lot of things, that is pointing that something is wrong with your code and it needs to be fixed. But again, especially, planners need kind of that public engagement, and these things need to be informed by the community. It's easy to go through a text amendment and just go out and find codes and, try to modify those. And some things, you can do that. But a lot of what's going to work in your county, it's not going to be what works in Teton County or Albany County or so.
Well, and that's what I feel like, and maybe I'm biased in this opinion, but I feel like we really have reached out. We
Yeah.
hold regular workshops is what we consider them, and we've had a lot of public comment and public input. I guess, like I said, because essentially where we're at is rewriting all of our regulations. So it's just, I guess personally, I feel like it's a pretty daunting
Yeah.
task. And would we be better off, like, is there a better way that we could break it down to where
Yeah, I
we
mean,
do sections at a time? And
I think you should set up the BOCC should decide to form a work plan around the LDRs. Quarter one, you're going to attack chapters 1 through, or titles 1 through 3. And you don't, public comment's very important. But I have working through every section and getting input on every section, and it was just a challenge. So, and it works for some communities and it doesn't work for some communities. Where I've seen where things work is if you set the public expectations. These are the quarters we're going to do these. These are our parameters we're going to set. We're going to release these chapters at this date. We're going to take public comment on these chapters for this long. We're going to have this public hearing and these readings for these sections. And I think breaking it up, this is like running a marathon. You just want to get aid station to aid station. If you blow by them, you're not going to finish, so it's better just to focus on those small chunks. And most of those titles, they're going to speak to each other. And then the other thing is you need to take a lot of time on the back end to make sure if you're breaking these titles up, that everything is talking to each other. Because that's probably one of the most challenging parts of rewriting. And I've rewritten several codes. And that's one of the most challenging parts, is making sure that all of your articles and sections and subsections, all of your links, everything, works together. But yeah, I think breaking it up and releasing not huge chunks, but larger chunks to the community to digest and have a long period to look at, I think that works, rather than releasing it chapter by chapter by chapter and taking comment on everything. Again, public comment's very important, but it can't be manageable if it's so bisected. That helps.
yes, no, it does. Because I think that that it is something that we found is that it's so great that we get a lot of public comment,
Yeah.
but it is very, very time consuming.
Yeah.
And
it's just more digestible by you all and staff if it's in blocks.
Mhm.
And then, people can understand that this chapter, it says something here that might be talking a little bit and it informs what's going on in this chapter. If everything is siloed out, people are making comment on something where they're not getting the broader context of what the
Right.
rest of the code is trying to say
Mhm.
and regulate. And then also I'll add that setting the expectation to you all, to elected officials and the community, it's a long process and it's a heavy lift from staff, whether staff is taking it on or even has consultants. It's a heavy lift for staff, and it's a heavy lift for you all and the electeds as well. But I'll go back to saying that if you're wanting to redraft your entire code, it sounds like, I think at least having some, I don't know how long it needs to be, but some large public engagement to really look at your comp plan to see what we're about to do the same thing in the town of Jackson. So we're about to do a comp plan update, and we're going to work with a consultant that is just going to find information from the community of what's working, what do you like, but it's really finding kind of those unintentional consequences, what sounded really good, and what we really thought was going to work, but maybe it's had some different outcomes than what we thought, and where do we need to redirect.
What was the stages that you went through in the town of Jackson to help establish your procedure for moving forward and coming up with this plan and choosing your consultant to help with this?
For the update that we're
Yeah.
about to go through. So planning director is putting together with our long range planner a kind of a scoping report to the town council. And that's just gonna kind of outline what the staff commitments are, what the proposed, at least estimated fiscal commitments of the town are gonna be. And then that will inform the town council. They've already asked for it, so they're obviously they're going to put that in next year's work plan to do. So that's step 2, is putting it in the work plan. And then it's drafting an RFQ. I think at least the idea is, because all we want at this stage is public engagement to see what kind of where the comp plan needs to go. I don't think it's the idea of anybody in the community or planners that the entire comprehensive plan needs to be updated. And it's a bit difficult because we have a joint comp plan with Teton County, and they're not likely going to go through an update. So this is really just the county focus. So it might just be chapters and sections that are changed here and there. But then we'll likely hire a consultant that likely will not be, there will have to at least be I would probably think some sort of, they've done planning work, but it will be a public engagement specialist and really going out and figuring out from the community what's working, what's not. Not going out and saying, hey, do we need, NL3 zoning here rather than here, but it'll be what's working in your zone district. What pressures are you seeing that you're worried about? And then going through that process, we'll get that feedback from that exercise done, and then we'll go through the comp plan exercise. And then, if it comes out that a lot of text amendments are needed, then we'll start that process. But
Why did you choose to go with the public engagement specialist over someone that is a planner?
we haven't chosen yet. That I believe is going to be staff's recommendation, because again, we're not really trying to chase down planning issues at this moment. I mean, we are kind of, but it's more trying to figure out what the community is wanting and what the community doesn't want, and where there may be some issues. So it's far more high level than what impact is this zoning district having on your neighborhood? It's what's going on with your neighborhood, you know, do you like the development? So it's just more broad brush than getting into the nitty gritty.
So Andrew, how long have you guys been looking at this? What timeline do you foresee?
I believe, so the comp plan update was put in this year's work plan. So that was set, you know, last year, but it's this year's. So we will probably, that scoping report is coming soon. So we'll probably try by the end of this fiscal year to at least have the process set up and even have that consultant hired. But again, I don't know kind of how those decisions will be made.
Have you been through a process like this before?
I have, not in the town of Jackson, but through several code updates. We called them kind of community visioning sessions, and they were just, you know, very broad community discussions about what was going on. Hey, we're gonna update these zone districts, or we're gonna rewrite these regulations. You know, kind of getting that information from the community, but again, keeping it more broad level.
I'm just interested in how you're going to do that.
What do you mean?
How are you going to reach out to your community? Yeah, how
have I in the past?
No. I'm just curious to how it will be communicated out to your community.
So
Information.
we're lucky. We have pretty engaged community. So most people know what's going on in Teton County and in the town of Jackson. We have very good response levels. I've worked in communities that we've had a really hard time getting responses. I'm on the Western Planner Board, and I give kind of a at Western Planner conferences, I give a bit of a canned session on improving public engagement and outreach. But the kind of the biggest lesson I've learned in the past is just going out and meeting people where they are. You know, having community engagements in this room, sometimes just that's not the place to do it. My session's called the Liars Bench, and I don't know if any of you all are from Southern Appalachia, but every community had a Liars Bench, and that was like where all of the elderly people and your locals went, and it was always at a gas station, and they would sit there and they would talk about everything. So we weren't getting community engagement in the first community I served. So I started holding meetings on the Liars Bench, and we actually started getting a lot of input on a downtown master plan that we were doing. And we would have never heard from those individuals, you know, if we didn't meet them where they were. So, you know, that's just the best way to do community engagement. Sending out a sterile survey monkey survey, you know, you'll get, you know, some input, but, you know, taking it further. And that's where consulting gets expensive if you are going to hire a consultant. Paying a consultant to go sit on a Liars Bench is going to take a long, that's quite the expense. So setting those expectations.
So we need to start having meetings with the cowboy. I mean, what I'm hearing.
And they probably have spike punch.
Yeah, exactly.
Thank you.
Yeah, thank you. Any other questions? I know you all have.
Punch. Yes. No. Punch.
Delicately.
Because it was discussed that it was Mexican food, so I requested margaritas, and I show up and there's punch. So then we were debating on if the punch was spiked. It's not. Christy failed us.
Let down tonight.
That was very good.
Yes, thank you very much.
My contact information, and you all have it. If you have any questions, feel free to reach out. You know, Wild Pass is here to help. Western Planner is here to help as well. So, and you know, just, I I'm one county over, so, planners need to stick together, and, share information and try to help out as best we can, so.
If you were to come back for the Board of County Commissioners, I would spike some punch.
I've got to drive home. And it's,
Container.
that's right.
No, this was very helpful. I feel like we have I think there's a lot to go through. Our comprehensive plan was written in 2003, and going back and looking at notes, it looks like there was an attempt to try to get public engagement. It might have been 10 years ago or so, but I didn't ever see an update based off of the public engagement. And they did go around to the public engagement took place in different parts of the county, but there was never an update. It doesn't really include much with implementation and like the policy directives in the comprehensive plan. That's just my take in it. But there is a lot of emphasis right now to update our regulations, and it's just there's so many different things that we're looking at, and it seems like that the tower regulations, it almost as much as we're struggling through it, it's almost a low hanging fruit because it's so independent. Like we can look at it independently from everything else. But it's like moving forward, just trying to come up with a strategic plan. We have there's a lot to do, and I think it might even be beneficial at some point. I guess what I'm trying to get to is we need you. I almost think just somehow for
Yeah, no, I don't mind to help
just
out.
to have some support, like at some point, maybe even just if we need to go back at some point to talk to the county commissioners about a strategic plan, maybe direction. But I do think for us to have something in mind before we go to them and not just, hey, we need direction from you. I think we should try to come up with a solution.
Do they set a work plan for you all?
No, they really are. Have advised more to get the feedback from planning and zoning.
Yeah. In several communities I've worked in, the Planning and Zoning Commission and the Board of Trustees twice a year had a joint meeting, just to set expectations, go over kind of challenges, whether it's with the commission or, challenges with kind of what's coming through the pipeline, but then also to get input on, what do you want us to work on? And then having those decisions on, okay, if you want these LDR updates, you need to understand that there has to be something that we're guiding these updates. We might think we know what we want, but again, I've seen a lot of codes where the community really thought that they wanted these regulations and they thought they knew what the outcome was going to be because of those regulations, but there was no kind of comprehensive thinking. Those were more reactionary. They weren't a product of something. They were a reaction to something. And I think that's the big difference in good regulation writing, is that they're not reactionary, but they're actually trying to forge something.
I mean, I think we have a ton of public feedback. I think we were making really strong progress until we handed it over. Then everything fell flat. Like, I think what we're missing right now is really who's authoring. That's the missing piece, because I think we have a lot of public feedback. I think it is comprehensive. We did address it comprehensively. Wasn't reactionary. A lot of different perspectives. I don't know. I mean, in my mind, I think we set a schedule and we do the work, but we do need an author. I mean, that's just the truth.
One other kind of key component to keeping that process as clean and smooth, it's not going to me, but as possible, is don't give the full package to the BOCC at the end. When you're breaking up these sections by quarter, they can't approve those, but have a very strong straw poll at each section or at each step of the way.
Good idea.
Because that way, if you need to redirect, you can do so at that time, and it's not that big of a deal. Cause I've, that's how I have at least done, large code updates in the past. In North Carolina, the big trend when I started out was you would take all of your regulations, your subdivision regulations, everything, you'd pull them into a unified development ordinance. And it was one code where everything spoke with one another. Every regulation was tied, and it was just one big cohesive document. And it was really easy to administrate and for the development community to use. Um, and we, in some instances, we would take it all the way to the finish line and have a public hearing and take it to the BOCC without all these workshops, and it was a disaster. So breaking that up, it adds work to everybody's plate, but it will take work off of the long run. Front heavy process. That's
Yes.
all right. Any other questions? I mean, you all have other business, but
You're welcome to stay for it.
I'm gonna eat and then I'm gonna try to I'm gonna beat the snow.
Good luck.
Well,
I know it's hard out there still.
for letting me come. So
Yes, thank you very much.
Great.
sneak in the back.
Really
and eat.
appreciate it.
No, we really appreciate it. This was awesome. Do you want a plate to take some food home too?
No.
And we have a whole nother platter. We just didn't know how much we needed.
It's great.
She did bring, she got tin foil just for people to take, your midnight snack.
You want to take a break or should I just run?
No, I was gonna take a break, yeah. So before we move on to old business, let's go ahead and take like a 5 or 10 minute break,
Yeah.
stretch our legs.
Be great.
And we will reconvene in a few minutes.
Okay. I think we can just.
Thanks. I used to work with John when he was, he worked for the county, I worked with John a lot.
Are we ready?
So are we recording? Did that work?
No, but I think we're just going to keep recording on the.
Oh,
Wonder-
that's recording.
Maybe I can record on my phone.
Yeah, I used to.
So why isn't
It is being,
batteries?
something is being.
Oh, just the battery doesn't work again.
Well, it says connecting. What is it connecting
To my computer, so it's like when it's connected, it doesn't let you record, so I disconnect.
Maybe the power's not.
I tried. I need to just, I'm wondering if it's the USB or something to the charger isn't working.
Well, there. That folder. Okay, we're recording.
Just keep an eye on it, make sure it's.
Yeah.
If it doesn't, I can use my phone.
I'll bring in my stone and my.
And we are recording on the video as a backup just in case.
Yes.
All right. I will call this meeting back to order. And we are moving on, going to old business, our tower regulations. Oh, before we go back though, I would like to say we're gonna close out this meeting no later than 9 tonight. Is everybody good with that? Okay, is that good for you to you two to get home especially? Okay, so we'll close this no later than 9. So moving on, looking at the tower regulations, you want to?
Sure. Why don't we just start with an introduction of this before we just dive right into, is this on? Okay,
Yeah.
before we dive in, let's just talk about timelines, what we have here, and kind of try to come up with a game plan. So following the last meeting, I did a little bit of redrafting of the regulations. I'd say it was pretty significant compared to what we did at the other meetings, and tried to do a little bit of more reformatting of this. And I guess selfishly, I was trying to make this make sense to me because I wasn't quite following where we were last time. So the reorganization of this, before we dive into comments, reorganization is to include definitions within this regulation. If you choose that you don't want the definitions in here, that is perfectly fine. I just thought it made sense for right now just to include the definitions in here. Following the definitions is the purpose. That all stayed the same. That was all pretty much, I won't say verbatim, there might have been a few little changes because now we are referencing some of the federal requirements in the regulations. Again, this, do want to point out, this has not had legal review yet. So between now and our next meeting, I am going to be working a little more with Clayton to try to do more of a legal review. So this has all just been in-house using some additional tools that we've had available to us to put this together. So there are some cross references to the federal regulations and FCC standards. So after the purpose, section 2, section 3 is the development requirements and standards. So our current regulations has a chapter 3, which is our development standards, and it talks about building heights and setbacks and floodplain management. So this section is almost, it's more of those development requirements that would somewhat fall in our development standards. So this is when someone wants to build a small wireless facility or a macro tower, they would be coming to these development requirements and standards to help guide them with where they place the tower, how they design it, what we require. It is not about the permit process. This is just about the development guidelines. So it is definitely more detailed than what we had before, and it is categorized. So we first have applicability, general, stealth and concealment, and that even the stealth and concealment, we talked about the stealth design not necessarily being a requirement. And it does say that this is wherever reasonably practical. So it's not necessarily a requirement to have stealth and concealment, but if it is for the situation, it at least has the guidelines to how to do it. So it's not just saying you have to do it. We're saying, how do we actually achieve this goal? Okay, scenic, visual, and community character protection, wildlife, environmental, and cultural resources, structural engineering and safety, ground equipment, fencing and screening, lighting, noise, and signage, interference, RF compliance, and public safety. And what I'm scrolling through right now, the blue and the red, these are just comments that I received. So I'm just trying to go through the format with you. We'll get to the comments here in a minute. Co-location and siting hierarchy. And then the next section is section 4. And this gets more into the permit requirements by facility type. So we start out pretty basic in the beginning, and then it builds up. So we start with our exempt facilities, and then it goes into the permit requirement for exempt facilities. After that, this is a new section that we have not talked about, and it's called eligible facility requests. And this is originally, I thought it would be beneficial to try, these are more the facility requests that are modifications to not have to do any permitting with us. And I might talk a little more with Clayton about this, whether or not we actually have to do permitting for these. Because according to what I've been reading, we should have some sort of permit for these eligible facility requests. However, these would be more of an administrative review and this would not be a CUP or anything that would have to go beyond our office. So it's more like minor additions to facilities for these eligible facility requests. And then it talks about what the review standards are and like the basis of denial in here. Next, we go into small wireless facilities and what the permit process is for that. And there is first administrative approval. So there's a permit that would be more administrative. And then there's also, if it is you would need a conditional use permit for any new tower or support structure that is used for wireless communications. And so that would require a CUP. And if the tower is higher than the height requirement in the zoning district, you would then have to get a wireless facility adjustment on top of the CUP. And the purpose of the wireless facility adjustment is it's in place of a variance. So instead of going through that variance process, you would go through this, and this is more specific to towers. So now those questions that we had about variances, we would no longer be having those questions anymore. So this part of it, I will say, was generally verbatim from the Teton County LDRs. And
The wireless facility adjustment?
The wireless facility adjustment, yes. And then the permit process, it goes through what the requirements are for each process. And I would say generally the permit builds up as the tower gets larger. So like, the ERFs and those exempt ones, they're very simple. But then once you start to get into the wireless adjustment, there's going to be more requirements. Following that, we then have and this goes through like the completeness determination, the approval criteria. I again made some adjustments since I sent this out last week. And then the next section is macro towers. So the macro towers would be a conditional use permit, and the requirements are also there are some additional requirements because the macro towers, these will all be ones that exceed the height requirements. So we are singling those out from the wireless facilities or the small wireless facilities. And this also has to go through the wireless facility adjustment process as well. So it's the CUP and the wireless facility adjustment. Okay. And then after that, we have a statement, just a section about expert review authority. I have added quite a bit to this since Thursday, just to provide some clarity of how we can go about getting an expert and what timing is best, because we do have to make sure that we meet those shot clock. And when we bring in an expert, we've got to be able to it needs to be very objective as far as what they are allowed to review versus what they cannot review. So we can't be having them do things that maybe we need to keep this more objective and not necessarily subjective, and technical, more of a technical review. And that when we can ask, it gives authority for staff to ask for this technical review, or, oops, there's an O, or planning and zoning or board of commissioners, and that there can also be follow-up questions to the expert clarifying, some of their responses. So the earlier we can bring an expert in, the better, if it does need to happen, because we still will need to meet all the shot clocks.
And then is it on us to provide the expert, or is it on the applicant to
We-
provide and pay for the expert?
The applicant may be required to pay for the expert. However, it would be up to the county to determine the expert and make sure it's someone that's independent of whoever the applicant is.
Okay.
And then the next section is, I changed this a little bit too. It's unified conditional use process and public notice requirements. So now this ties back into chapter 5, which is our conditional use permit process. And anything additional to that is listed in here. And really, it's almost, we're just saying, when you are doing your conditional use permit, the process is still consistent with our other CUP processes, but now we have some other questions that go with it. And they still need to look at the findings that are provided in that CUP process. We do have a little bit more clarification about the property owner notifications, because this may be different than the distance that we have to notify neighbors is more than in a normal CUP. And I also I would like to at some point provide a little more clarity that the applicant needs to be the one to send out the public notice, help us send out the notices rather than us having to do all of this. So I'd still like to work on that, and it's not certified mail. So I think people could bring in the letter to us, we approve it, and we can actually take it upstairs to district court and we can put it in a little mailbox and they'll take it to the post office for us. So even if the applicant provides us the envelopes with the stamps, the letters, we can still, that's our way to certify that we know it went out, because we can actually put it in the mailbox. So, okay, then after that, we go into the permit fees. And rather than specifying them in here, we just say that it's by a fee schedule. And then we have section 5, which is the long-term compliance, maintenance, and abandonment. And I would say overall, this stayed fairly consistent with what we had before. There are some additional things in here now, and some of this was feedback from Lance too. And I think just from some other review comments. And then the last section is the miscellaneous provisions. And I think some of those still need a little bit of work. But anyway, this is where we are right now with this. In the blue in here, that's just the overall outline of the regulations. So trying to make this a little bit easier for everyone to follow the process. And when someone comes in for a permit, they have to check which one of those it is. If it's a small wireless facility, a macro facility. There are some big questions that we still do need to answer. Going into timeline, I have already advertised that we will be, the Planning and Zoning Board may be making a recommendation to the county commissioners at the next Planning and Zoning meeting. So that meeting is on January 15th. And that the recommendation would be going to planning to the commissioners, possibly for review and adoption on February 3rd. So the reason there's that timeline between the 15th and the 3rd is because the next BOCC meeting is the 20th, and that just wouldn't be enough time to get them everything. So there is like a little bit of time between the 15th and the 3rd. But if we do need to change it, we actually had to advertise those dates separately, like our advertisement notices.
Commissioners are different.
They're different. So if we need to like pull one of the advertisements, we have time to like adjust our advertising. We already submitted it to the newspaper, but one of the advertisements for the BOCC meeting hasn't been published yet. So we have to meet the certain timelines. So I guess that's one thing I wanted to bring up is I feel like we are on a pretty tight timeline right now. And I just try to figure out do people want to try to stick to this timeline? I personally feel like too, this might be something we need to talk to Clayton about to see how much of this review can be done before that meeting. If we need to schedule a special meeting, how comfortable are you guys? Like, what if changes need to be made after the 15th? Can we still make those changes after the 15th and have it be recommended? I don't know. I'm kind of new to this process, but I wanted to bring, at least with you guys, I'm new to the process of how the workings of this. But I appreciate too the comments that we did receive because this was sent out last Thursday. I will say, I wish I would have had a little more time to have worked on it. We had the final plat for the subdivision out in Daniel, the Mountain Meadows subdivision that went to the commissioners on Tuesday. And I had to put quite a bit of time into getting stuff to the commissioners, and that was due. I got a pretty significant extension on that. So all day Thursday, I was working on that. And this agenda was due the same day. So I was kind of struggling to get it all ready at the same time. And I wasn't able to do like that final review on this that I wanted to. But I appreciate everyone's comments because I do think we are able to move forward. Having received comments when we did, we overall have 46 comments from Chris, Tammy, and also Lance. So I think though it's been really helpful receiving these comments because a lot of these were things that were like, oh wow, that could be just stated more clearly, some inconsistencies. Even just some of the regulations with Lance, he does have some good comments, but I also felt like some of these we might just need to talk through as far as, okay, I understand the comment, but how do we address that comment? Also keeping in mind protecting the county when it comes to like the regulation. So, but every comment is in the handout that just is, what is it called? Tower
Regulations.
Yes, the comment. So every comment is there. It says who made the comment, what my response is, and then if it's been addressed in the regulation. So some of these have not. I've worked on this today and yesterday, so it's just been like 2 days to try to get all this done.
Yeah.
But I was like, I had a friend helping me. My special AI friend maybe helped me a little bit with some of this stuff. Okay.
Call it Susan.
So he did. And I actually was talking to him before this as well, because I feel like this was a regulation. I don't know what I would have done without it. Unless we had like that model regulation, and Clayton had shared that one model regulation, but it was like more of a specific, it was more municipality regulations. And I was trying to go through it and was just like, this is almost like more over the top than, and actually I fed that regulation, our AI did use that. Susan did use that as a guide. Susan.
You obviously did a lot of diligence.
There was
Exactly.
a lot that went into this beyond it.
Susan needs to be.
Susan needs a lot of watching.
She needs a lot of supervising.
So I think though the comments, we are getting there. I think we are taking a step forward because some of these comments have been addressed, but I'm like, we still have a little bit of work to do here.
I mean, this is just over. You really don't have to do the comments section.
I needed to like, I can't look at the comment boxes on the side of a Word document. I
So-
need to see them together.
I would agree. This is a ton of work, but this is how my brain operates too. I like to see it here and then have the reference. I think this is phenomenal. Like, I'm super impressed with this, honestly. I know a ton of time went into this and I can't tell you how much I appreciate it because really this is how my brain works, is exactly how you laid it out. And I do appreciate that
Yeah, thanks.
very much.
Well, how do you guys want to, I mean, we have 30 minutes and everyone turn on the AI.
So, you know, what's really funny is I actually just watched a South Park that was about AI and how everybody was using it. It's really funny. Long story, but it's super funny.
Gingerbread.
I mean,
It was AI.
People thought I went out there and smashed it.
I feel like it took 4 days to draft it, to come up with the first draft.
I
It
can
was 4
imagine.
days. I took my computer home and was like prompting it through the weekend. And it was, I was impressed, but also surprised by how long it took. So it was like my review time and trying to restructure things. I just was like, wow, this actually, now I'm kind of down to a time crunch because I thought it was just going to spit it out in like a couple hours.
Susan's not.
And also, you asked about like process and stuff. I love if we could start the next meeting personally. I would also say like in the past, when I feel like when we make good progress, like what earlier I was saying, like we need an author, like you're obviously we did. Like if it seems like if we could, in the past, what's worked well is people read it before the meeting, come in with specific questions about specific sections, but otherwise, unless there's an objection, question that we need to discuss, like we just say, yeah, this looks good. So we will.
And I think this one is a little bit tough because these comments are new to everyone today.
Right.
That's the part that I think is a little challenging, is that they are new. I do have a couple of topics that I think might be worth talking about, if you guys want to just hit on a few topics.
I think that's a good idea.
Okay.
Yeah.
So the small wireless facility definition, I feel like that changed a little bit, and it originally was a fairly lengthy definition, and then it shrunk down. And based off of one of Chris's comments, I started going back and looking into that definition again, and it did not have a height that was associated with a small wireless facility. So it now does reference 50 feet. So it does have to meet all of these criteria to be a small wireless facility. And that now includes 50 feet. And that even though it is 50 feet, we still have to meet the height requirements within the zoning regulations. While it does distinguish the different small wireless facility, what is it called? Eligible facility requests and the macro facilities, we don't really get into zone districts heavily. So it's more, you have to go through the CUP process, but we don't really mention in the regulations zone districts and where is it okay to have some of these, where it's like the exempt facilities can really be anywhere, but it's this, the small wireless towers versus a macro tower. Are there any conditions as far as zoning that should be considered?
We did talk about this.
We did, but we left it we didn't have an answer.
We just talked a lot
Yeah.
about it. Yeah, but we never really. Yes.
We never really came to a conclusion. And I think one thing I did want to mention was we have in the regulation, also everyone now has the linkable development code, right?
Yes.
Okay, yeah. Actually, I should send it to you.
I know, but I can't access it. Don't.
So we have our zone districts, which talk about the allowed permitted uses. And then we also have man, I can't read anything on my screen. There's also a section, it's section 18 of the development standards, which is minimum site area. And the minimum site area, it also talks about like how each zoning type has a minimum site. And if you look at this towards the bottom, we have guest house or cabin, and it has like a minimum site. So we could address it in this way also, you know, where it has to have a minimum site area if you're going to put it in residential. Just in case it's like, oh, we're okay with it being an R5, but maybe there does need to be some sort of, this could be a way just to
That's a good idea.
have some sort of,
Restriction.
yes, for like the residential areas. Depending on like what type of facility it is. Or we also can address it by just the zone district, which would be, you know, where we actually list it in the zone district. Or both. It might actually make sense to be in both because that's seems like we have that for a few of the different uses. So I'm done rambling, sorry.
No, you're not.
No, you're not.
I do like the idea with the residential.
Having a minimum site. So you're,
But would we, like, are we talking about, I mean, I would, any macro, I would personally think like a macro township.
Right.
Small wireless
a
facility.
small wireless facility. I would agree.
But when we talked about looking at it in different zoning districts, that's exactly what we said. We can't imagine, you know, a macro tower being in a residential area, but would it, should we say that or,
Yes.
I mean?
I
Okay,
can't
that's-
imagine climbing in a bathtub with a hairdryer either, but some people do. So.
Wow. I love it. I love it.
And I think the residential tricky because there's certainly some circumstances. Rule when we did the small wireless facility. World. Bridger maybe made less sense, you know, and a lot of this comes from feedback. Yes, please. we-
Right.
They need us.
Right.
Everybody.
Right.
Ready services.
Yeah.
But the minimum site area is useful, like, because then you say, well, if it's super dense, it makes less sense. That's what the minimum site area.
Mm-hmm.
Wouldn't be possible. to say.
And that for those situations, it may be beneficial to encourage the carrier to provide more small wireless facilities rather than a
As
large
opposed to a
tower.
macro.
Yeah. To provide that coverage.
Mhm.
Oh, that makes sense.
What's the minimum site area?
That's what I'm wondering. What's the minimum site area and should it be based off of the,
Oh.
Oh,
Chase is there.
oh, he can't
oh,
hear
he
you.
can't hear you, Chris.
And he can't unmute.
All right, we see you, Chase.
Security.
I'm guessing that's better. I'm talking to the microphone.
Yep.
What's he up into though?
That,
Yeah,
he-
now I can unmute. Yeah, okay. I got kicked out and came back in and I think it made it so I couldn't unmute my mic.
What are your thoughts on that, Chase? Did you hear everything that we were talking about in regards to particularly the small wireless facilities, if we wanted to add in the stipulation in there, a minimum site requirement or site, what was the wording, site size?
Yes,
In
minimum.
residential or in all zoning types? What was,
Well, that's what we were talking about is like, if we wanted to put it specifically, like specifically in residential, it needs to be this minimum site size.
yeah.
Yeah,
I mean,
how we
I
want.
think
down.
generally I would support, just as we've talked about with other use types, like protecting residential to a higher degree than other zoning types, I think is appropriate. I don't have any, I guess, strong feelings on what that minimum site requirement needs to be, but yeah, I think being more protective of residential is appropriate.
Yeah.
Curious, too.
So I'm trying to think of like small wireless facilities, like about how much room it takes up.
I was just having a memory. I think in our, about this, that we pull in our reg revision,
Oh,
like the cabin thing that you pointed out was
Yes.
like the only thing that was in there that was like that. I'm like, that should live in the development standard, not in the minimum.
I'll
site
tell you
area.
right now, that
Moved it.
cabin thing is like, when I found that it's about guest houses, and I was like, this is like, I remember in the beginning, I was like, where is this? I remember seeing something about
'Cause that's
2
the only
acres.
thing that's in there that's
And it's
not
in
a
such a weird
district.
spot. It is so weird how it's there. And I feel like it's come up a couple times. And I've always just thought it was a little bit odd how it's placed there.
So I guess that would just mean maybe, I think what we did in the rewrite, which this board may or may not agree with, was we just put that in the development standard, not under the minimum site area. Because it's the only thing, it's the only thing
really
like that
is.
in that entire list. So which the conversation is still relevant. It's just about where do we put it? Maybe we put it in the
Yes.
development standard instead of in that section, but
You're
It's
right.
all
We
the
could
same.
just list it in section 3.
I like that idea that you brought that up. We should do that.
Having the minimum.
Yeah.
I think it would help for residential. I
Mhm,
mean,
I
because
think
then I'm
so.
like, I think about where I live and I'm like, okay, the way it's written right now, it could go on my neighbor's property, but if there was a minimum site area, I'd be like, oh, well, now they can't, but like they might have to go to an agricultural zone that's nearby. Or
Or they
Yes.
need to use like a full lot instead of someone's backyard. You know what I mean? Like,
But would that be, what do you think though about it being a primary use on residential? Like that would be the primary use on a residential lot.
I think that only works if it's incidental use, not primary.
Yeah, it almost seems like it would need to be like a,
Incidental to the residents.
yeah.
For a small wireless.
And I
facility.
think we actually did add that. That is now in here. Where is it?
But they could, if it was a primary use, it doesn't mean they couldn't do it though. They could, they would just have to get a CUP, right?
If it was if we say it can be a primary use in residential, they would just have to get a CUP. But I think what is changed is saying that like it has to be incidental. Where is that? Hold on a second. I wonder if that shouldn't be in the permit. That should be the guidelines. Okay, it's right here. Oh, but I think it has to do with. I'm on page 9. Small wireless facilities installed solely for the benefit of a single property or occupant shall be considered accessory use, which is an exempt. And then
Right.
commercial small wireless facility operated for the provisions of wireless service for the public shall be regulated as wireless facilities under this chapter as, oh, wait.
So
As,
remind me, doesn't this go back to the discussion we had at our last meeting about, I mean, a small wireless facility, don't those like repeater radios fall under that? Or are we talking about like a standalone tower type thing?
It could be either.
Because, I mean, obviously, if we're using the repeater radios that's affixed to somebody's garage or a house, like, I don't want to restrict residential to, it has to be all that's on a residential lot. If they're just trying to extend range or something, like, those are pretty
And that's-
small pieces of equipment.
it would be an administrative approval.
Yeah.
Right. I think the way it's written is in alignment with what you're saying, Chase. I
Okay.
think. Did you?
And I think that's where we're saying if it's commercial, but I'm wondering if this needs to be, it's regulated as a wireless. I don't think that should say wireless facility under this chapter. I think this needs to say,
Well, it makes sense because
Does
it's
it make
basically because other the first part says you don't need a permit if this is for like if if Chris wants to go put a little antenna on his shop or something,
Okay.
I don't need a permit for that. But if you do, then you got to follow this section C, small wireless. That's how I read it.
Yeah.
okay, I
I would
want to
agree.
make sure I'm,
Yeah.
Yeah, the way it's written, I think is fine. It was I think just some of the comments that were made previous to this about use in residential. Whether it's, I guess, the primary use of a lot. That doesn't seem to make sense to me.
wonder though if we need to say commercial small wireless facilities. And somewhere it needs to, does it say it's accessory or? That's the comment made.
You have in the first sentence.
But we don't
You still
mention
leave
it for
it in.
commercial. So for commercial, it needs to be. We have to follow the regulations of this, of like getting a permit, but it isn't specifying if it is a primary use on the parcel or a secondary use, if it's for commercial purposes.
I think it's about the use of the facility, not of the property. Like if it's a if me, Chris, wants to go put that thing on my shop, then that is an incidental use.
Yes.
That right. But like it's the use of that thing that is incidental to my living there.
Yes.
Right.
But if it's a commercial thing, I want to put up a tower that tower is a primary use because I'm not a resident, I'm not residing on the property, my use of that thing is about a commercial thing only. So
That's what I'm wondering though. We mentioned the commercial small wireless facility, but we don't say if it has to be primary use or.
I don't think we have to though, do we?
Okay. So it's okay if it's the primary use on the property. If we
Well-
have a minimum lot size, maybe it doesn't matter.
I think a commercial use of a tower on a residential or any like zoning district, but let's say residential here, the use of the tower is the primary use is the commercial
Okay.
thing. So I don't
It
think we
doesn't-
have to say
Okay.
that it's primary. I think we can just say you have to follow this process if
Okay.
it's a commercial use,
I agree.
which I think is what you've written.
Okay.
Mhm.
That one's,
Got a little lost in translation.
but
Just admit.
I'm sorry.
No, it's not you, it's him. It's fine.
Yeah.
I have to think about it. And it's.
But I-
totally fine.
But I guess what would be if it does have to come down to lot size, what would that lot size need to be?
Yeah, that's a tough one.
So what,
Wouldn't the lot size depend on the size of the tower when we're talking about the?
Yes. Well, it would be by tower. Yes. Yes, by tower. Yeah.
Maybe instead of saying lot size, there's a restriction on.
I can't hear you again, Chris.
That's Clayton, but I'll give the mic to him so you
Oh,
can hear him.
sorry, Clayton.
To get up.
I just assumed it.
I like it when you confuse me with Chris. He's smart.
Does anybody notice how clean shaven Clayton is?
I think the word you were looking for was handsome.
But I still have
but
my
the point
beard
of-
for the record.
What's that?
I just wanted everyone to know I still have my beard.
Well, I would be an asshole and say I still have my hair, but I won't. So anyway,
My suggestion was maybe instead of lot size, the restriction is built around the ability to build a tower in that space within a fall zone on the lot size.
I know, we talked about that, but then I think though it's going to be permitted in a lot of residential zones then.
But maybe that's the issue that you're looking at when you want to make sure that because if you say, for discussion's sake, if you say you got a minimum lot size of 5 acres, okay, there are places in the county where there may be that it makes sense to, and there's available property, and you have a willing landowner, so on and so forth, that has a 3-acre lot that would work well in that for a small wireless facility in that space, but you've said, oh, 5 acres, so they're kind of locked out. And yes, you're pulling up exactly what I'm thinking about is areas in Barger. There's places, Greener Ranches, I think, has some smaller pieces depending on where you're at. But if essentially we're looking for the safety of that area, because that's the issue for your tower height is your fall zone. I'm anticipating. I don't know though. Just a suggestion so that you're not creating a rule that is hard to work.
I like that. I forgot that we had talked about that using the fall zone as a
setbacks.
right.
So if the way that, and the reality is like, I've got 2 pieces of paper right here. This is my yard, and this is Chris's yard, and they're right next to each other. And I have a house and a barn and a shed. And Chris has the house, but nothing else here. My lot is 5 acres. His lot is 5 acres. But he actually can put a tower on his because the fall zone won't impact any buildings. Whereas the actual setup of my lot, I can't.
But we also have something in here about how the fall zone can also be based off of the engineer, depending on how the tower is designed to safely fall.
Yeah.
So it's like, I just think though, we're going to, and I do know the town has this in theirs where it has to be within that certain fall zone. But if we make it where it's not the height of the tower, I think the macro towers, there isn't something limiting it because it's not the whole, it's not 150 foot. That is the fall zone for some of those towers.
I mean, maybe we're just trying to use the wrong tool. I think what we're actually trying to navigate is like, there are certain circumstances where there's a certain amounts of density where towers would be more of a problem for neighbors rather than places where there's less density and people would care less. Maybe a minimum site area just isn't the right tool to address that. Maybe we just need to say in RR5, it's okay, but anything under that, it's not. I don't know. But it's also about a tower or pole. Like if someone puts, I mean, the thing in Barger was like a small pole that was on somebody's barn. Like that, there's no rational basis for a minimum site area there. And that's a lot different of an animal than erecting a new tower.
Yes.
Even if it's small wireless facility.
Right.
And small wireless facility is limited to 50 feet. So like, that's like, I feel like that you aren't going to have the issues as much with your fall zone.
When it would be 30
You
in
know.
a residential.
Right.
Limited to 30.
I don't know.
Right. No, I think it's a good idea. I just think for the macro towers, I'm more thinking the tall ginormous towers. If they can
We should
engineer it where all of a sudden your fall zone isn't the height of the tower, then it might have an issue.
Right.
But okay, so let's just start small. Let's start with small wireless facilities for the thanks, Clayton.
Yeah.
Small wireless facility that is like the administrative really is like it has to be attached to a building, right?
Right.
So that one can be in any zone district. Theoretically.
I think so.
And it doesn't seem much different than putting like a satellite dish on the side of the building.
Mm-hmm. Okay, so small wireless facilities that fall within the CUP requirement. And It's just the height requirement of the zone district. What about those?
What about it?
So these ones now we're moving from the admin review to the ones that are a CUP. So
Which is erecting a new pole or tower.
new polar tower. So yes, so what zone districts, is there any restriction for that?
And this is where it's the issue of keeping it away from residential.
I don't know.
Right, potentially.
Okay, so I think what would fall under this is the LR communications pole. In a way, like that is this situation because it's 30 feet, you're within the height requirement. But it's a standalone structure.
The existing pole is 30 feet, or is it higher?
I think it was 30
It was
feet.
30,
Mhm.
yeah.
And they even said they were gonna go over 30 feet, so they really didn't even have to. That's the thing
Right.
that blows my mind. They wanted 50 feet.
They wanted.
They originally
50.
wanted 50.
Mhm.
But I'm like, really, if you're limited to 30, you're limited to 30 feet in most zone, besides ag
So-
zoning, right?
So we're
Ag
talking,
is
we're
50.
talking
It's different in
primary.
industrial too.
right?
And
Mhm.
I mean, this is still, we're still having a discussion on whether this is personal.
No,
Because
I
you
mean, for the
don't-
purpose of this conversation, it's commercial and it's erecting a new pole.
A
or
new
tower.
pole, yeah.
It wasn't Bowman. Thank you.
And whether, and yeah, why wouldn't we just stick with the regulations for each particular zone district?
Mhm.
I don't think we have to.
Well, I don't think, I think most people would be against a bunch of towers popping up in residential areas with no, just only permits and not going through some sort of process.
Well, exactly what happened here.
Yeah.
Folks didn't want, I mean, the folks didn't want it. Wasn't one person who did.
Yeah. So, I mean, in my mind, I think residential,
But would they have to
what's
go
the
through the
question?
process anyways? I mean, would they, I mean, if you're erecting that, and that you would have to go through.
so
the
you're saying it would be a
application process.
conditional use of residential. That's what you're saying.
Yeah.
And
I
when,
mean, that's how I feel about it, is that it should be a conditional use, a standalone.
Residential, R, R5 and up or something. Or mobile home parks with towers in them.
I think Teton County, theirs is, you can't have them in MH zoning, I believe. I have to go back and,
Just looking at it.
I think I remember seeing that somewhere, but now I'm.
I don't know.
The only
But-
thing I wonder about, like, my question is, would that come before us anyway? And we would decide that's not an appropriate use for that structure in that
Yeah.
particular residential?
Why not cut it off for that?
Yeah, but it could be tricky to say no.
It could
And
be,
you have to be equitable, very difficult,
But you may have public comment around that and.
but we
they
can't,
just
right, but we can't, it's not, you can't say because more public doesn't like it, we're gonna say no. That's not
Right.
that's not a regulatory basis.
But what I'm saying is we write the regs based upon the public comment that we did receive, saying they didn't want it in their residential
That's-
area. That's what I'm saying.
So we have a criteria that's based on whether the public wants it. I don't think we can.
Well, no, I'm saying, no, I'm saying we're writing the regs based upon public comment.
The factors.
And that's what I heard when it came down to Jim Bridgers. The residents didn't want that in their backyard.
But really, that was only 2 residents up there.
No, it was like 4.
But there's a lot more than 4
Right,
residents.
but those.
But we
we're
heard
only
from
supposed to-
2
we're
that,
only
that,
supposed to be listening.
but there was
One.
2 that wrote in that were in favor of it.
Was
They
it?
felt like, yeah,
Mhm.
because they felt like it was replacing an existing pole that was already there. I mean, it's one thing to erect a new pole. So, maybe there would have been something different there, but. I don't know.
That's
mean,
also
my-
one application that we had where, we had a few people against a particular application where, we've identified other towers in residential areas that benefit many more people that I think don't mind having it there, like Barger is an example, Big Piney. And so writing regs based on the Jim Bridger application, I think would be a little short-sighted.
Well, that's all the experience I have. Chase.
Well, you know, expand your mind a little bit, Sammy.
That's a good point. I do think to that point, like the way that these regs are written, there would be a basis to say no to one, or, and I'm not, but let's not pick on Bridger, but like just say an instance where, you know, the one in Big Piney, there was a need, the one in Bargerville, there was a need, that those were fulfilling. If there's criteria about is it filling a need, then
You should just
the Bridger
elaborate.
one was not, and the Barger and the Big Piney ones were. This
Yeah,
has-
so I think I mean, just based on those couple conversations we've had and a very enlightening training, you know, the previous half of this meeting, which, you know, makes me a little nervous about conditional uses in general. Just having enough regulation to where we can look at something objectively and be consistent in those applications. I don't know that I know what the answer for regulation is, but if it can be somehow based on necessity, you know, I guess with the only caveat there being, is it, you know, if the first company that comes into a area that has a need is then like any second company or third company that wants to also provide service to that area, then not necessary, you know, like, are we going to stifle any kind of competition in those areas?
I think it's one consideration or one factor among many, not the consideration. I think I can imagine circumstances where we would say yes if there were already several and someone wanted to put in a new one. If it met all the criteria.
Is that a comment about this?
But that is a fair concern. I mean, right, we don't want to pick winners and losers of wireless companies. But I think based on the way that Haley has written these, like I would feel comfortable that that would not be the case.
I think though also the way the regs are written for small wireless facilities, CUP, there isn't anything that says you have to demonstrate the need through any sort of, and I remember you had a comment about that, Chris, and I had that one marked because Lance had a comment about small wireless facilities.
You have
It was-
something on page 11. It's under the small wireless facility CUP baseline permit submittal requirements. H, documentation demonstrating the public or
Oh, you're
community
right.
need, coverage gap, capacity need, and service deficiency.
Okay, you're right. Just kidding.
But I don't know if that's under macro tower.
That
too.
actually should be marked as new. I don't know why that didn't show up blue. That's new.
And I think right now that only lives under small wireless. That's probably.
It does because the macro says all applications shall provide the following in addition to section 4.1.
Okay. But that says they have to supply
You're right.
documentation. It's not identified as a consideration or a factor. So if they provide the documentation and we said, well, it's not fulfilling it, they would just say, well, it's not a fact. You don't have to fulfill it. It's not a factor. We just had to provide the documentation. So if we do want it to be a factor, we should put it in maybe the submission process as one of our factors for consideration, along with section
The
3.
approval criteria.
Yeah.
Okay.
Oh, yeah.
Okay, so we're getting on 9 o'clock. So let's refocus. So I think we just need to make a decision where we want to allow the small wireless facilities and if it will require a CUP in certain facility or in certain zoning.
I think if they need a tower, I think if they put up a tower or a pole, I would personally say, let's not do it in residential. Do it off of an existing structure. Like, and then in larger lots, sizes, okay. That's I heard. I don't see, that to me feels like a compromise that allows all things to happen.
So are you, just to clarify, so just in residential, not allowed, but like rural residential, the bigger lots, they would be allowed? Is that kind of what you're saying?
I don't know where, I don't know if the line is at 5 acres or 10 acres or what, but
Because I could definitely get on board with that if it was just them not be allowed in residential, but then I would, in my opinion, I want to say my thought is an RR5, like nothing less than an RR5 is my thought.
I think that's fair. So they could do it in RR, but it would be like they'd have to put a pole on a barn.
Right.
But in RR5, they could do a tower.
Yeah, in order for it to be a new tower, freestanding pole,
And it's
have to be
okay.
RR5 or bigger.
So my brain is melting. So again, just to re-clarify, small wireless facility is just like an additional antenna or something on an existing structure, right? Remember how we got off track on, I feel like we're so close to getting off track onto pole versus small wireless facility.
We already did distinguish that though, because the thing that's attached to a building is just a administrative review versus a new pole or a small tower that's under the height requirement is the CUP process.
So a small tower under the height requirement
Which
is can still be categorized as a small wireless facility?
Yes. Yes. It's still a small wireless facility, so there's almost like there's actually 3 separate processes for small wireless facility. There's the administrative process, there's the CUP process if it's under the height requirement, and then there's also the wireless facility adjustment if it's over the height requirement.
So the small wireless facility is like the little the little dish, and then whatever electronics and stuff are associated with it, and you can put that on a building, you can put that on a pole, you can put it on a tower. So we're saying where it lives on a building, that can be RR. Where you want to put up a new tower or new pole to mount that to, then that would be RR5 or higher.
Yeah.
Gotcha. I just wanted to clarify. Yeah. Probably go.
Well, do we just want to put that in for now, just so we
Yeah.
have something in there?
I think so.
Let's just do that. And
Yes.
the other thing I wanted to bring up about the heights is that we have height requirements for principal buildings and accessory buildings. They are not the same, so I just want to make sure we're referencing the correct height when we say it cannot exceed the height requirements of within the zone district.
And
Does that make sense? Because the principal,
It should be consistent, right?
we do need to be consistent, but principal is saying that
Oh, yeah,
it's
because
30, but then accessory, there's like
some of them, your
variation.
accessory can be
Taller.
taller.
We have a height table. Where's that at?
It's it's section 9.
Yeah. I mean,
so one of my questions is if you go taller, can't we just implement our rules of a variance?
We're not doing a variance anymore though. That's where the
That's
wireless facility adjustment comes in. We're doing that instead of a variance. Because it's more applicable to towers.
So yeah, that gets confusing when you have all the different language. That's confusing in terms of trying to, like he said, trying to match your code in different sections of your zoning plan.
It's referenced in here though, like the CUP process, it tells you to go to chapter 5. This says the wireless facility adjustment is all in this chapter, and it says this is basically in lieu of a variance. So like this, it tells you if you have to go to a different section.
Okay, so I say we put it in there for now. As we had said. And then we'll circle back around to it before we do our final.
Second that.
Can we bring the restriction up? Can we just talk about it?
I don't know if we can do that. Well, it's regulation. It's regulation. Try to talk about the height.
Good God, I am gonna wear t-shirts.
I would think just make it whatever the higher one is.
Yeah.
If it's
Whichever
35,
one is,
Yeah, whichever one
just
is,
go with 30.
yeah,
just go with the higher.
yeah.
I mean,
That
then
a
it's,
different deal is
it's,
confusing.
because I'm like, the MH says 15 right there, and I'm like, holy cow, that is like, that would be
Oh, yeah.
ridiculous. That would be, I'm like, that's
That's
pretty,
Yeah. Yeah.
Right, so in the principal building, it says an MH can be 30, so in that
Yes.
case, we'd go with 30.
Yeah.
yes, whichever is larger. Okay.
Yeah.
Okay. I guess, what do you want, what should we do for next steps?
So do you guys think we should have a workshop middle of January before our regular meeting? Fair enough.
I hate to say it too, what stinks about the January meeting is January 1st is on a Thursday. So now it's like
Early.
we have
Oh.
an early meeting in
Yeah.
January.
Do we have anything else on the agenda?
We do.
What do we-
There's a double minor subdivision. So
Is it gonna be?
the
complete?
caddy,
Double.
it's complete. I just haven't put all my stuff. There's 2. Yep,
Okay.
yep.
Gotcha.
They're doing them together. So I don't think it'll be super complicated, but there is something else on the agenda. And we
So the question
advertised,
is-
we advertised for it.
Or that's the other, that's the thing.
That is the thing.
Okay.
Yeah.
Well, we could go over some of this again in our regular scheduled meeting. And then maybe do a workshop after our because then that,
I don't know if we. Leanne, can I ask you a question about advertising? So we met the requirement to advertise saying that something might be adopted at the January 15th meeting. Are we like, if say we don't adopt, say something isn't adopted at that meeting, but it'll be ready like the following week? Do we have to advertise that again or?
We have a no more.
Yes, it's, we do for change, we do.
That can't be more.
It's more, yes, something like we had to advertise this January meeting, we had to advertise twice because there's an application and regulation change. So we had to do like 2 separate advertisements to meet the requirement.
So whatever our window is.
We'd have to do it. We might have to, it's just so hard to meet these windows. I don't know how to.
Why don't we just, can we do this? Can we just say that we could adopt it at the next 3 meetings? I mean, can we? Can we do that? Is that a problem?
Well, because you have your specific.
I understand.
We have to meet it in a window. And it has to be within a window of time. It's,
Between both.
So
the
we can't
P&Z
just
and
keep
the
repeating. We can't just keep.
you can't, it's like, we have like one date we
Because
can
there's no way we're
advertise
gonna be
it.
ready by January.
I
15th.
know.
well,
I knew that when you
Maybe.
first said that. I'm like, there's no
you
way.
don't think?
I feel like too, because like it's so early on in January because of that Thursday.
I mean, do you think we will be? There's so
I
many
don't know,
unanswered
if we can,
questions
if
still.
we can kind of, if we're able to sort of communicate this more than just during the meetings. you
That's
know,
what I'm
the
saying, if we
interim.
can email the information.
Collaborate it, but you can each, then that would be.
Right.
Sort of an electronic meeting.
Mhm.
You can all make your own changes. You can submit them to Haley for like a clearinghouse.
Well, yeah, because that's what
Okay.
we've been doing.
You would. An enviable position to be in, but then you could draft, come to the meeting, review the latest draft.
What if we did even just a special meeting on Teams or something? Would we need to, would we need to? even? Like. And how do you feel like your timeline would be to do a review?
I get a full review in the.
That's what I'm like, is that even possible?
You know.
See, and that's where it's like, we really need a full legal review.
Well, one of my.
Oh, word by word, all the shells and the maze. Exactly.
So this is what we. Sugaring like constitutional law, like. Short-term rentals. So like we workshop to a point where. Felt like we were. Really close or basically done, then we had advertised the public hearing on the. Like a larger meeting. 2 hour, sure, the public hearing on these regulations. Basically had it done, and we advertised, so we hit the window and a decision was made. Reflection.
That sounds right. I don't really remember, to be frank. Sounds right.
Because we went through. And kind of like the press rehearsal was like, okay, everybody show up, forever speak your.
Maybe-
Hold your piece, got all the edits, then advertised and we handed it off to the commissioners, they had their hearing. And
So what if January 15th was our,
Dress rehearsal.
was that dress rehearsal? But do you feel like you could, I think that is the thing. I feel like we need your review before then.
I think.
But do you not think so?
It's like, January 15th.
Too soon.
Well, because we don't have anything over.
Well, so that's the thing is I think if that's our dress rehearsal, we gather it all up together and then get the final
For him to review.
for him to review then, and then in our next meeting, he can bring up anything that's major that we need to change. And that's pretty much the final like push.
So, okay, so pretty much then, if everyone else could provide comments on this, let's
Mhm.
try to figure out the zone districts. I could go back through, do some cleanups. Jan, you don't even, I guess, need to review it.
Start working on what,
Okay,
and then any changes are made on the 15th,
then,
I need.
okay, let's do that. Okay,
Yes.
so we'll just then assume all P and Z comments. The thing is
So
though,
give us a deadline.
Yeah, tell us
We-
when you need them.
So you need them by the
Week
7th.
before.
by Christmas Day.
Maybe the week before.
I think the hard part is I have to have the agenda published the week before the meeting. So it makes a really hard timeline for me when it's like, I don't have much time to work on it because
We would literally have to get this to you next week.
that's the
Yeah, because
problem.
Ideally, you would do a revision, we'd all be able to review before that meeting.
Yep.
Come
Yeah.
in.
So theoretically, I should have all the comments, unless we did it kind of like this meeting where I crammed in the comments and gave them to you at the meeting, but I just don't like doing it.
But it's hard to
Like
make
that.
progress.
It's really hard. What about if we said January 5th? That's a
By
Monday,
January 5th.
Monday, January 5th.
It gives you.
And I already
Okay.
have Chris's comments. I have your comments. So, and I think
You guys don't get to make any more comments is what she's saying.
Well, that's what she did with this.
Cut off.
She wrote,
No more.
Are you done? Like, I.
Oh, and I guess, Steve, do you have comments?
Yeah.
I'm like, if you have comments, but I mean, I feel like Lance did, he had quite a few comments and some of those might be more legal review comments, the ones from Lance.
So,
So,
yeah, so let's say all of our comments need to be to you by January 5th.
okay,
And then at our regular meeting, after our application, we will hash this out and get a, do we want to say a final rough draft? That'll be passed on to Clayton. And then at the next meeting, then we can finalize it for good, vote it in.
that will be, what day is that?
But I mean, just make sure you.
Yes.
Yes, we need to, we're gonna have to look at
Our
that. all.
meeting is the 15th, is that?
The notices are absolutely ridiculous. Like, it took both of us quite a bit of time to just
And the
add
sad
and
thing
subtract
is that who
45
even
days.
reads the paper?
Well, this is the whole thing. We need to start moving away from the paper and get to more electronic means.
But I think, isn't that more of a, is that a state thing? Yeah.
It is.
Yes.
Call up Mike Schmidt and call up Laura. Get on it.
Okay, so do we have any public comment from anyone in the room?
So glad you sat here.
Are you sure? Steve,
I know.
tomorrow's my ugly sweater party. You should guys, you'd be glad that I didn't wear that thing. It's pretty impressive.
Last thing on my chat GPT.
Haley and Christy, thank you so much.
Yes,
Thank
thank
you,
you guys.
Thank you.
It is a lot. Okay, so if nobody has any other comments, I will adjourn this meeting at 9:17. Thank you, guys.
Thanks for dinner.
Take some with you if you want. We have a lot. Clayton, thank you. I feel